We have allowed this application, though it is not in format for
Lordship,
adjournment.
Lordship,
And who is for the respondent number one?
Lordship, myself, P. Both.
You are for the respondent number one. So when
Lordship.
will you file the affidavit, this WS?
Lordship, at least 2 weeks may granted, your Lordship.
2 weeks. So
Yes.
accordingly, give a date after 2 weeks.
Okay.
But before vacation,
Lordship.
what is the date of vacation in Itanagar? Itanagar.
16 October. 6 October. 6 October. Lordship.
6th October. Same. So 5th is the last same. So we'll fix it on 4th.
4th October.
4th of October.
Lordship.
4th of October. And what about the other respondents, 2, 3? It will proceed expert against them.
Lordship.
Nobody has filed any application.
My lord, I have done all my destitute respondent number 2 and 3.
That you have filed affidavit. None appears.
None appears.
No, nothing is filed. So it will proceed expert. We have granted time to respondent number 1 to file written statement.
Lordship.
But Mr. Counsel, be careful. This is an election petition.
Lordship.
It's not the way to file application. Yes.
Lordship.
Obliged.
Very ill. This today is not the day for seeking indulgence, Lordship, but I have consent to seek an indulgence, Lordship. One tender notice was issued on 7th of this month, Lordship. And last date is today, Lordship, 10 days. Out of this, Lordship, there was 2 Sundays, 1 second Saturday, and Sunday was also internet shutdown, Lordship. So we are not, sufficient time has not been given, Lordship. I just pray for extension of time. That is only the prayer, Lordship. It
Who
will
is
be
the,
taken up
who is the
today.
department?
Social welfare, Lordship.
Yes, what is your response?
Not received the copy, Lordship. Let me have the.
No, we have filed yesterday. We have filed yesterday, Lordship.
It was unlisted that.
You have the instruction. If it is his limited grievance that there was holidays, but it is online,
Online, Lordship.
then why you need a day holiday?
Lordship, to upload and to get all the necessary particulars, copies and all, Lordship.
How many days given?
Lordship, 10 days time, Lordship.
No, 10
1
days. How many?
1 week time.
1 week was given.
Oh, Lordship, 10 days time was given. Out of that,
Fine. Others, nobody
there was
has
2
done.
Sundays, one
Difficult.
second Saturday, Lordship. And
Maybe
Sunday was internet
Now
shutdown, Lordship.
it's online. We are taking cases from
Lordship, that's true,
Itanagar.
Lordship.
No,
To
this
upload
can't-
the documents and all, Lordship.
why? What is the problem uploading documents?
Lordship, because we have to get confirmation thereafter to search for the GM number, Lordship, all this.
What GM number?
That is government e-portal number, Lordship, all this.
Everybody has done it.
Lord.
That
Sufficient
cannot be a
time was
ground
not
to.
given.
come
Lordship,
to-
in same, Lordship, on 24/8, one tender notice, another tender notice was used, that was extended up to 12/5, Lord, 12/9, Lordship.
You have the instruction
Lordship.
that this is the situation. We are taking up at 2.
Lordship.
You have your instruction. This kind of petition is filed. What is your instruction as regards extension of time for 2, 3, 5 days?
No.
12/5. What is the other? Earlier was extended to?
That is not true, court. They themselves has extended.
That's why. What was the date, last date?
It was 26/8, Lordship.
26/8.
Lordship.
You have the instruction.
Lordship. Deeply obliged, Lordship.
May I please, Your Lordship? I beg to make a mention for item number 2 of the daily list, Your Lordship. Lordship, there is some personal difficulty. The arguing counsel is not available, Your Lordship.
We'll allow your petition.
In
We'll allow your petition. That's all.
in that case, can it be taken up at 2 PM, Your Lordship?
We'll allow you your petition. There is a similar judgment. We'll ask the appellate authority to take it within a period of 3 months. That's all. Your grievances, until then you will be protected.
Your Lordship.
That's all.
May it please, my lord.
But be here for, we'll require your dates and periods. Yes.
May it please, my lord.
Mm.
Prayer for listing of a motion matter, my lord.
Mm.
Can it be taken up tomorrow, my lord?
What is the issue?
My lord, e-challans were imposed against us, my lord. We are a transport company, but there I am alleging certain malefied against that, my lord.
What
Certain
is the
sections-
urgency? E-challans of how much money?
My lord, varied amounts, my lord, total tender amounting to 3,34,000.
Uh,
My lord, what has
When
happened?
you required, when is the last date for deposit?
My lord, the date of deposit is gone. My lord, what I am alleging in this petition, my lord, is that certain malefied was caused against me.
No, we understand. What is the urgency? Let us
My
know.
provision test I am not being able to take until and unless I don't pay the said amount.
Ah.
That is my grievance, my lord.
If you don't pay, there will be no
No
pollution.
pollution
certain-
test, that is why my vehicles are dormant. My lord, tomorrow,
Tomorrow.
highly obliged.
My lord, with consent from the other side, I beg to mention item number 39, my lord, of hearing, my lord. May this matter, my lord, fix after my lord holiday on 29th October, my lord.
We'll ask them to give it in a part two hearing list.
My lord. Part, there is some urgency, my lord.
Last time also it was
Yes,
adjourned
they took,
Actually,
my
last
lord,
time we took election, my
Yes.
senior was about.
last
to
time,
do-
my lord, for last
on the
session.
prayer of the learned council for the parties. Item number?
Item number 39, my lord.
Item number 39. On the prayer of the learned council for the parties, list this matter after puja vacation.
Okay, there is an interim order that.
Interim order pass earlier shall continue until further orders.
Obliged.
May I take your lordship? Lordship, in the item number 5 of today's release, lordship, we have filed our affidavit. That may be called. That affidavit was filed on 16th.
May I please, your lordship? With the concern on the other side, item number 40, your lordship. Today we have some difficulty.
Item number?
40. And we come after vacation, your lordship.
List this matter on the prayer of the learned council for the
Petitioner, your lordship. T.
petition
Gogoi, on
Huh?
behalf of T. Gogoi,
on behalf of,
TJ Master, your lordship, senior counsel. TJ Mahanta.
okay, on the prayer of the, who is, have you taken consent from the
Yes,
respondent?
lordship. Yes, see, yes.
On the, as agreed to by the learned council for the petitioner, learned council for the petitioner, press for an adjournment on the ground of having difficulty. On the ground of difficulty of Mr. T.J. Mahanta, learned senior counsel. Prayer is not opposed, but so accordingly, substance allowed, list in the month of November.
May it please your lordship. Lordship, listing for an urgent matter for tomorrow or for unlisted, my lord. What has happened is a tender matter, my lord.
Mm.
The honorable, we had filed a writ petition where the honorable high court allowed a writ petition directing the PWD road to look into the grievances in a way as per the tender notice.
Mm.
And accordingly, we submitted representation. But now what they have done, they have gone against the NIT and have issued a tender to the private respondent where we being the lowest bidder, we should be awarded. So, my lord, yesterday only the order has come, my lord. Otherwise, grave injustice will happen, my lord.
What is the tender for?
My lord, construction of building, my lord, administrative building in 6 Mile, my lord. This is G plus 7 story, my lord.
Now, your, what happened? Why are you came before this court on urgent?
Earlier, what happened, my lord, our technical bid was rejected.
Uh-huh.
But the Honorable High Court interfered and said that the reasons for rejecting the technical bid is absolutely illegal
Uh-huh.
and directed the matter to be placed against before the PWD to
Okay.
take fresh consideration.
Okay,
Now they have rejected us that we are being a subcontractor. Whereas in the part of the NIT, they were nowhere mentioned that being a subcontractor, I cannot participate in the tender bid. Now they've come with a new reason, which is not there earlier. And we've been the lowest bidder. Now, if the bidder who has been given, there is 14 crore difference, my lord.
okay,
My lord, tomorrow or unlisted,
tomorrow.
much obliged, my lord.
May I please, lordship? Lordship, I beg, with the consent of the other side, lordship, I beg to mention item number 41, lordship, for adjournment.
Item number?
41, lordship. The conducting counsel, Mr. A.R. Bhuya, is not well, so lordship, I will take up the matter some other day.
Conducted counsel or petitioner in person?
Petitioner in person.
Tell us, there is a difference.
Yes, lordship.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed in the month of December 2020.
May please, your lordship, I'm praying for listing of a matter, your lordship, in admission, lordship. What happened, lordship, though there is a interim order, lordship, that the third party rights should not be accrued,
Mm.
but they have come up with a interim tender and
What is the subject matter?
Lordship, it is like, we are providing trucks for LPG transportation, Your
Okay.
Lordship. So I'm praying, Lordship,
Your contract is continuing.
I have challenged the, means like the bid of the respondent, private respondent.
Okay.
And the court has said that the in the meantime, the private respondent has been blacklisted, Lordship,
Okay.
because he has submitted some false
Mm.
documents.
Mm.
So, but for an interim measure now, they have come up with a different tender.
Mm.
Lordship,
For
so
interim.
as an interim measure for 6 months. But what happened, Lordship, the petitioners are again deprived from participating in the interim tender, Your Lordship.
Why?
So though they have appeared, they have participated, Lordship, and we have filed our additional affidavit also, Lordship.
Mm.
But they have said that,
But
Lordship,
it's a new cause of action.
it's a new cause of action, Lordship, but we are not against the interim tender, Your Lordship. We are not against it because there is some administrative exigencies, Lordship. Transportation has to be done, Lordship. That's why, Lordship, let them
When?
Lordship, any date, Lordship, 19th or 20th, Lordship. I'm not traveling for tomorrow or 19th or 20th. Maybe on 20th, Lordship. It's a Friday.
So many
There,
matters.
it is not inconvenient, Lordship.
Huh? 20. Hmm? 20 or any
It's
other?
not inconvenient, Lordship.
20.
20. Much obliged, Lordship.
Wait, please, Lordship. Lordship, I beg to mention item number 7, my lord. Earlier we had submitted an adjournment slip yesterday. Except part of the series.
You cannot.
Well, in fact, what had happened because there was this letter was circulated, my lord, so we also couldn't prepare, my lord.
You have not taken our consent. We'll hear this meeting.
My lord, we will, I'll pray for my lord tomorrow, my lord. then.
No, it cannot be your convenience.
Today, my lord, since they have listed, they have circulated the letter, my lord, we also.
They seek an adjournment in item number 7 alone.
My lord.
This is fundamental.
এখনো কিছু, এখনো। My lord, I'll pray, my lord, because this issue is, some legal issues are there, my lord. AG will appear. So, my lord, tomorrow, my lord.
No, that cannot be. On last occasion, we have said to Mr. Bhattakur that this is the issue.
Right.
Whosoever addresses, we have not called the Advocate General.
My lord. My lord, kindly tomorrow, my lord.
We have not called the Advocate General. Advocate General will call when we are in difficulty. It's up to your prerogative. You engage Advocate General or whosoever. We have not concerned.
Can it be taken up tomorrow, my lord?
No, tomorrow we have already fixed this meeting.
My lord.
See, if we adjourn this series, what will remain with us to do?
Difficulties, my lord, yesterday.
In a system, in a way we want to fix this matter
Well,
in a way that
well,
so that we can decide
my lord,
matters.
my lord. Since the letter was circulated, my lord, we could not prepare, my lord. We are under prepared.
No, please don't be in that because this is a consent between you. We have not given consent.
My lord.
We have not given.
Tomorrow, my lord.
And there is one method. We could understand that the whole series is everybody has given. One person will come and say that we have difficulty. Whole series will fall.
My lord. And this being the lead matter, my lord.
Point, this is not the lead
No,
matter.
but,
Lead matter is something different.
But they start.
Lead matter is item 6. Mr. Chaudhary has argued on last occasion. I
Uh,
Chaudhary. On that day, they were not here.
Yes, my lord.
We were there, my lord.
But
Your
the
senior counsel was not here.
Senior counsel.
And then
was
today
another
also he's not
member.
here.
whole episode started with 7, my item 7.
Maybe we do
My
not know.
Well, kindly
Nobody
take it
argued.
tomorrow, my lord.
this one. How much cost?
My lord, actually, affidavit was also not filed, my lord. So we were under the impression that the affidavit will be filed.
If you go
and
further,
subsequently-
what affidavit is required? It's a question of law. What affidavit is required? Any facts is required to be decided in this case? Any facts is there? This matter was heard at some length on so. A prayer for adjourn, and this is a series matter consisting of matters, give the total numbers, first of all. An adjournment has been sought for by the learned counsel in item number 7, which this court is not inclined to grant such adjournment. However, the learned counsel representing the forest department makes an submission, seeks also an adjournment on the ground that they did not prepare the matter as a as a adjournment notification was circulated yesterday, and that the state is inclined to engage the Advocate General. Full stop. In view of the aforesaid, though this court is not inclined to adjourn this case, inasmuch as a substantial time has been spent on the last occasion, substantial judicial time was spent on the last. However, at the insistence of the parties, the matter stands adjourned and be listed and be listed in the month of December 2024. Full stop. Interim orders passed earlier shall continue until further orders.
Grateful, my lord.
And this matter shall not be treated as part heard any further.
Lordship, I beg to mention a fresh matter for listing tomorrow, your lordship. On day after tomorrow is the last date for submission of bids, your lordship. We are challenging the NIT and the bids opening date is 20th, your lordship. And in fact, your lordship, it is the NIT is for engagement of transportation contractors for transporting PDS articles, your lordship. In a similar, it is for Dhemaji district. In a similar NIT for Kamrup district, there has already been a stay order passed, your lordship. So, your lordship, I'm praying. Motion, your lordship.
Tomorrow.
Day after tomorrow is the last day.
How many matters are there in tomorrow's list? That including that means. Including motion. No, here. Including motion. Okay.
Much of it.
May I please your lordship? Lordship, item number 33.
Item number?
33 and 34. My senior counsel is not available, so kindly pass over the matter after 2 weeks.
Senior
Immediate-
counsel,
Not available.
who is your senior?
Please show.
So what?
Earlier, several occasions they take a judgment. Her senior is available there. I met her, but he is not.
Yes,
Said it-
yes, PPCD is there.
Yeah.
We'll just take up this matter. Yes, prayer rejected. No, আজি তো দিয়া আজি কি দিলো আজি তো অবজেক্ট দিয়া নাই কালি কাৰণে
May I please, your lordship?
Yes.
My lord, the NDPS case, my lord. Scan copy may kindly be called for my lord.
And the best case.
Yes, my lord.
Why this is listed before this court?
Second, my lord, he was arrested in the month of April 2023. Case was succeeded in the month of August 2023.
No, why this is listed before this court?
My lord, earlier it was rejected
By this court.
by this
Okay,
honorable.
scan copies. After vacation.
Kindly on fourth, my lord.
Hearing.
চাই লবা কোনটো কেছ
কোনটো আছে দুইটাতে আছে এইটো এপিয়াৰ হয়
You have appeared?
Lordship, in item number AB 1170.
AB
he has not
1170.
appeared, my lord.
No, we appeared, my lord. We appeared, we submitted the certificate copy. My statement has not recorded.
He-
I appeared, I submitted the certificate copy also, my lord. But I requested but my still has not been recorded. my lord.
Other the statements are there, all there, my lord.
Okay.
All, and my lord, he might not be involved also, my lord, because so far the statements and the statements of the co-accused, my lord, they have admitted that it is a fact that they have dragged the girl to the jungle, my lord,
Hmm.
and tried to do bad act. Thereafter, the girl fled, my lord. That has come out from the statement given
But
on.
what about, what is the statement of the guard?
Yes, girl, my lord, but
What is the statement of the guard? Tell us.
lordship, yes, it is recorded, your lordship.
Show us. Because we have
It,
granted interim after perusal
Yes.
of the case diary.
Because your lordship has recorded in the interim order also.
Huh?
Yes.
Heard, Mr. J.
Lordship.
Huh? We'll grant it. Or you have serious objection?
Because my lord, they have admitted in the interim because so we can,
Admission before police.
no, my lord, yes, that is one aspect,
But
my lord.
one aspect, and
And my lord,
if
and all-
there is a statement of the girl
yes.
against them, then it would have been
Yes,
different.
they are, she has implicated that only thing, my lord, some that the mobile was given to her, that part. Otherwise, my lord, two aspects are there, my lord. Statement under interim and under duress, my lord. It is given under interim, my lord. And other witnesses and other co-accused, they are also on the same line. They have
Now,
come.
where is your 164 statement?
I have flag mark.
164.
Lord.
Now,
Same.
then now who is that single person? There are who are these petitioners?
Your lordship, kindly see the statement of this petitioner, Babul Sheikh, my lord. I have flag mark.
Now, is there any identification?
Um, at,
It is a right. She says
yes.
that I can identify the person.
Later it was identified that has come out from the statements, madam, from the witnesses, madam.
Which witness tell us?
In the last paragraph, last witness, I have flag mark.
Flag mark?
Yes, madam. In the last part of the city, madam.
Who is this Babu? Who?
This is a petitioner, madam. He is one of those four persons. He is in item number 33.
Who is in item number 1170?
He is, my lord, one Adut Sarkar, my lord.
Adut Sarkar.
Adut Sarkar, my lord. According to CD, my lord, that perhaps he may not be involved.
4 persons are involved.
Yes, okay.
One is
Babul.
Bablu.
Bablu. And same person.
Bablu, just a minute, huh?
Yes, ma'am.
Bablu,
then
then
Lalchan
Nurul, Lalchan,
and Rekib.
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 Now, who are these petitioner?
This petitioner, one is my lord Adit Sarkar, another is Bablu.
Another is
Babu.
Babu.
বেলেগ
What is the name of this petitioner?
this one is my lord Babul Sheikh,
Huh?
another is Adit Sarkar.
Abud Sarkar.
Yes,
Abdul
Abdul Adit Sarkar @Adut Sarkar. Then naকি?
Why there is no identification period?
Because they are not arrested, man. They are on AB, my lord.
No, even AB you can do that.
Yes. Well,
We are granting to Abud, not to Babu.
And not only Babul, paragraph 7 only, sir. Just paragraph 7 of my
Paragraph
petition. Very interesting, my lord. Why I have been implicated. Paragraph 7 of my petition. Babul. Yeah,
Paragraph.
Paragraph 7.
paragraph 7.
Hard.
Only the death reasons and medical also not there. Medical is.
What medical will be there?
A learned friend
Hard.
appeals for the informant.
Oh, forget about her. She needs an adjournment. We do not like hide and seek. Hard. Mr. J. Ahmed, learned counsel for the petitioner, also heard Mr. MP Goswami, learned additional public prosecutor for the state. Yes, what do you want to say?
We have objection.
What opposition? Tell us.
I am newly joined, so available.
The notices were duly served upon the informant. Informant has engaged MST Som. And what is your name is there in the MST Som. First of, she is not present. However, she has her junior is present. Junior, namely
Swapnali Sud.
Huh?
S Sud.
S. Chaudhuri. Full stop. She only submits that she has that the informant is having objection to the prayer made and nothing more. Full stop. The application under so this is item 117, the bill 7. See the other case that received and perused the same. Pursuant to this court's order dated 6/6/2024, the petitioner has appeared before the IO and he has been.
That statement is not there. He may be directed to appear,
No,
because
somebody is there.
yes, other Babul Sheikh.
Babul appeared.
Babul appeared.
Okay. First of, not necessary. First of, not peruse the case diary, including the statement of the victim girl. The victim girl could not identify the accused in her statement, though she specifically implicated 5 unknown persons to the unknown person had attempted rape on her. Full stop. The eyewitnesses also stated regarding the hue and cry raised by the victim near the pond. Full stop. The other accused, the accused persons, namely, uh, what is that?
Nurul statement is.
Accused persons, accused are identified to be, just a minute, identified to be one Nurul Haq, but he's a juvenile.
Can be statement can.
Huh?
Statement. Now, my lord,
One Nurul Haq. Nurul Haq is not before us.
not before.
One Nurul Haq, one Babu, Elias, Babu,
Babul Sheikh.
Elias Babul Sheikh. Babul Sheikh, Elias Babul Sheikh, one Lalchan, and one Rakib. Full stop. The petitioner Abdul Adut Sarkar, alias Adut Sarkar, has not been named by any of the witnesses, including the victim.
And
Full stop.
other accused.
Victim. Therefore, the interim protection granted to the petitioner under this court's order dated 6/6/2024 is made absolute, subject to, in the same terms and condition, with an additional condition that the petitioner shall appear before the IO within a period of 10 days from today, and on his appearance, the Page 82. When it was decided, 1/9/2023.
Yes.
And when the interim order was passed?
That interim order was passed, 23/6/2023.
20, what was the mandate of the interim order?
23. The Lordship will find this order in the IA, your Lordship. I have page 11 onwards. In the page 75. The operating part will be from page 78.
Okay, yeah, it was, it was directed to pass an order, but
After page 78, your Lordship will see fourth paragraph.
uh,
In view of the projection made in this repetition, which is supported by entry made in cheetah number so and so, cheetah dated that a separate DAG was created pursuant to order passed in partition case number so and so. While determining the matter in case number so and so shall first determine whether he has jurisdiction to cancel the order of mutation under the provisions of so and so, and thereafter he will fix another date for passing final order in the matter.
where is that order?
So he did not pass any, he did not take any decision in terms of the honorable court's order. He straightway decided that September 2023 order, page 83. The direction was that he should first decide whether he has jurisdiction to cancel the mutation. Because this mutation was done in pursuance of an order passed in the partition case. Page 78, your Lordship may kindly see page 78, fourth paragraph.
Yes, government has filed affidavit.
No.
We are checking for everything.
You file it. File it. We'll take it up this matter after vacation. We'll decide the entire matter.
My lord, the repetition is not maintainable. There is provision for appeal against the order of.
That we know. That we know. But we'll have to look into how a officer can pass an order when a specific mandate is given by this court.
Right.
That we'll have to see. And you'll have to satisfy what is the jurisdiction in such a circumstances to recall the order. Or it ought to have been, it was passed by the circle officer. Whether it ought to have been before the deputy commissioner an appeal.
It will come as a part heard.
Partner. Partner.
My lord, the repetition is filed against one report of Lat Mandal.
That we understand. His whole case is that the report is given and his apprehension is happens to be
The final order.
Correct.
The question is.
options here. If the mutation is whether the officer will have a power to recall his order. This is one aspect. If that is permissible, if you can satisfy that is permissible, what should be under which power, then of course, we may dismiss this petition, relegate you to that. Isn't it? Because that order has been passed without determining what High Court has said.
Yes.
Forget about other things. There is a specific order. That order is not been challenged in any of the forum. That is another aspect of the matter. Can you allow a circle officer to sit over a specific direction of a high court. File an affidavit and ready to face consequences if it comes before this court. No. Affidavit on the part of the statement, affidavit on the part of the state respondents, either in the IA or in the made petition shall be necessary even to determine the present IA. Mr. J. Henry, Learned Counsel, press for 3 weeks' time to file an affidavit. Prayer is allowed. Please this matter on
29th of 31st of October.
31st of October 2024, interim order pars alia shall continue till then.
Obliged.
Yeah, please, your lordship. Lordship, I am praying for further time for taking the dusty service, my lord, because the petitioner's mother expired, my lord. They could not come to collect the copies I have, my lord, they taken from the registry, my lord.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after vacation. In the meantime, what you want to do?
I'll take the dusty service I have collected from the registry, my lord, but they could not come to collect from it. It is for, for service.
The dusty service may be completed.
Much.
No, we shall accept. Let's go.
I am appealing from respondent, contaminant number 2, 6 and 7, lordship. And I have got the instructions for the same.
This is not our concern.
Lordship, regarding the payment, lordship.
Before you acquire a land,
Lordship,
you should deposit the amount. Is it a proceeding that you will take land thereafter? Oh, when
no, that
at
is
the
not-
at the leisure time, you will think over what should be the amount and will pay.
Lordship, that was a mistake committed from the administration side as well as from the water resource side also.
That's
Because
why. That's why.
after it has come to the
Who has
notice,
committed
that is
fact
why
should go to jail.
that is why we are repaying the same, lordship. We are rectifying our mistake and we are paying the same, lordship.
When?
Lordship,
We have not seen anything,
No,
any
we have-
commitment.
No, we have already paid 1 crore, lordship. There be a balance amount that is for 2 crores we have given.
What is her amount? We are concerned about her. What is your amount?
My lord, as per,
As per the award.
maybe 2 crore 90 lakhs, 3 crore 90 lakhs.
And
Amount is 3 crore 90 lakhs. lordship.
huh?
Total amount.
How much have you received?
No, my lord, not receive any amount.
How can it be, lordship? Because we have already paid 1 crore. That is reflected
1
in
crore you have paid to whom?
to the DC, and accordingly,
Yes.
DC will release the check.
They are not accepting the amount, my lord.
Why?
1 crore.
It's there with us for disbursal, but they are not accepting.
My lord, if court directed to receive the without any prejudice remaining balance amount.
What
then we have
prejudice? You write down that without prejudice, we have accepted it.
prejudice
How many petitioners?
Okay. 5.
total 5 petition number.
Pursuant to this court's order dated 9/9/2024, Mr. R.M. Das, learned counsel, has produced a status in respect of non-payment of land acquisition compensation to the petitioner. Full stop. Which is detailed herein below. Okay. Type it. Mr. Das submits that out of total amount, an amount of rupees
1 crore. Total is 3 crores.
94
lakhs. 94 lakhs something.
Uh,
1 crore something has been released.
1 crore 104,688.50 lakhs, isn't it?
Yes, yes.
Has already been deposited in the account of the collector for disbursement of the disbursements of compensation. However, they are taking all required measures
Yes, Lord.
so that the remaining amount can be paid to the landowners. First up, Mr. Pegu, learned counsel appearing for the collector, submits that the petitioners are not accepting the aforesaid amount, though they were not. Now you will see RTGS. Okay, and not furnishing the details of the bank account. And learned counsel for the petitioner submits that they are ready to accept such money without prejudice to their right, inasmuch as, according to the learned counsel for the petitioner, there has not only been delay which entitling them for interest, but they shall not be prejudice for. You want to go to reference?
No, my lord.
Interest. Full stop. That's all. Full stop. In view of the aforesaid, it is provided that the petitioner may accept the aforesaid acquisition amount after following due process without prejudice to their right. List this matter after in the month of second week of November. Second week of November. Full stop. And on the next date fix, Mr. RM Des shall give the updated status as regards payment of remaining compensation. Okay, you are for? A dash for respondent number 1. For 5.
May please, your lordship. Lordship, in this matter, an application for the restoration, my lord, of the writ petition number 4/02/22, my lord, and this was for default on 3/6/2024, my lord.
What was the writ petition?
My lord,
What was the writ petition for? Subject matter of the writ petition.
my lord, that on 3/6/2024, and there was a heavy rain at.
No, we understand. What was
Yes,
the
my lord.
writ petition for?
My lord, a writ petitioner was elected as the president of Zangoni Kaladoba Gao Panchayat in the district Nagaon, my lord. My lord, contesting candidate file an election petition, my lord, before the Panchayat election tribunal, my lord, Nagaon. my lord, and then trial, after the trial, petition has been allowed, my lord, but judgment, my lord, writ petition page number, my lord,
Read petition.
11, my lord, page number 11, my lord. And ordered at 4/6/2022.
The period is over. Why should you entertain all this?
Yes, my lord.
Period is over.
Yes, my lord.
What will you gain by exercising all this? Period is over, is not it? When it was over? Now new election will be held.
Yes, this on process, my lord. So probably observation doesn't survive.
Where is the notification? Heard the learned counsel for the petitioner. The present application is filed. Be happy for restoration of writ petition WPC for restoration of WPC number 4102/2022 dismiss for non-prosecution on 0306 by an order dated 03/06/2024. Full stop. The who has filed this application?
Petitioner advocate on record.
Advocate, my lord.
You have
Yes.
filed the affidavit? Who filed?
No.
Monwar Hussain. Who is Monwar Hussain?
Is attending advocate to the plenary.
Applicant is the engaged lawyer, my lord, for the petitioner.
Uh-huh.
Applicant is the engaged lawyer for the
Okay,
petitioner.
okay, that is what I was just. By the present application is filed for restoration so and so so and so. It is explained at paragraph 2 and 3 that due to unprecedented heavy rain on 3/6/2024, resulting heavy traffic jam and water logging, the learned counsel for the petitioner could not attend this court in as much as it took could not attend the court. Could not attend the could not remain present when the matter is called, in as much as he somehow reached the court at 12:30 p.m. 12:30 noon. However, in the meantime, the matter was dismissed. Considering the nature of considering the ground and that for the unintentional fault of the learned counsel for the petitioner, the litigant should not be allowed to suffer. The present application stands allowed registry to restore WPC 4102/2022 to its original file and list this matter for hearing and list the writ petition for hearing. Not hearing any, is it admitted? List the connected writ petition as far as that.
Public.
After application. We'll dispose it of.
I'm sorry, my lord, I was in court number one.
We'll dispose it of.
Lordship, we filed an affidavit, my lord.
What affidavit?
They have not made the mandatory pre-deposit of 20% of the disputed demand, my lord. And in fact, my lord, they have not filed any stay application before the appellate authority. They filed an application before the, my lord, the assessing authority. My lord, affidavit has been filed already. My lord, let it
Okay,
come out day after
Mr.
tomorrow.
The learned standing counsel for the
Respondent
respondent number
2 and 3.
2 and 3 has filed an affidavit which is not on record. Registry to verify and take the same said affidavit and list this matter in the motion column on next Wednesday.
Interim to continue.
Interim order pass alias will continue till then.
Apply. 20 seconds. Lordship, can it be on 27, Lordship? 25th, I'll be out of station.
Then before the 27th is not possible.
This week itself, your lordship.
This week, next Friday, Lordship.
Huh?
This Friday, your lordship.
This Friday.
Lordship, deeply obliged.
Obliged.
20.
My lord, here, my lord, revenue has filed an affidavit yesterday, my lord. And we have to file reply, my lord, because new facts have been brought.
No new facts. In fact, it is a part of the record. We had called for that affidavit.
Even then, my
Lordship may be pleased to fix the matter next week or day after tomorrow because we have an urgency, my lord.
This is a vizier.
This year and my lord, they are admittedly, my lord.
No, that you understand. Earlier they did not file an application. They went to the division bench. Division bench has rather opined against them.
Against them. And
Though it was their appeal.
And of
Mr.
late-
Boro, I have seen that. Yes, when to remove the ventilator? Tell us.
The government, it is pending before the government. The Deputy Commissioner report is sent to government for taking decision.
Now tell us when.
After vacation, my lord.
After vacation, it will.
Because I have to file a
What
reply. my lord.
you want to do what? What reply? They have filed and replied
No,
to your
they
affidavit.
have sent a proposal to revenue, my lord.
Revenue, it
Government, my lord.
has been now sent to the revenue department.
They have not
Revenue
taken decision.
for what?
No, in terms
For
of,
taking decision, my lord.
in terms of earlier order passed by this honorable court.
Ah.
Because way back in the year 1999, a leeway was given to them that you file a representation before the deputy commissioner, he will transmit to the department. That's much.
settlement.
They did not do.
Hmm.
Then they came up with successive writ petitions. In one such writ petition, my lord, in one such writ petition, which was put to challenge before the division bench.
That we have seen.
Yes,
No,
in that writ court order, my lord, a leeway was given to them that you file a, okay, you didn't
Fresh
file,
settlement.
now you file. And then also they didn't file, just before filing of this writ petition, they filed a representation. Now it has been sent, my lord, to the revenue department. The revenue department will take a call.
We'll dispose of them. You take a call.
That's what,
They are positive.
that's what.
No, my lord. The affidavit they have annexed, my lord.
What do you want this court to do? Tell us.
No, I have just filed an affidavit because my prayer is very limited to a notice they have issued. So I have delayed in filing.
No, understand. Whatsoever decision admitted position that this is a vizier land. Listen, Mr. Borwa. And that has been affirmed by division bench. Even if you say it is not correct, then you will have to file a review before the division bench.
Save the single bench order, honorable single, by
Order
saying that.
single bench order is limited to giving you a representation,
That much.
nothing more.
Yes.
So therefore, for settlement, they are saying that we are sending it to the revenue authority for consideration. What remains to be decided in this petition?
Absolutely,
That
absolutely.
the revenue, they are saying that they are waiting for the report as per their new affidavit. They are waiting for the revenue department report. That
Revenue department.
What is
report-
they may
revenue
take some
department
time.
Now,
And what do you propose? Suppose you are considering. In the meantime, what will you
no,
do?
my lord, admittedly, he do not have a case on merit. Now, at the end of the day, it is quite possible that on the, acting on
Who
the,
is in possession?
we are, my lord.
they are in possession,
for
they are in
34
possession,
years.
they are in wrongful occupation.
No, that we understand.
Yes.
So you will have to take a call. You are saying that we have forwarded it to the settlement office, whatsoever for settlement. You will have to take a call either way. If we dispose it of, then we'll have to give a protection till your disposal.
That is what.
That much we'll close this. It is your own case that we are considering for settlement. Till then, since it is for maybe a month, maybe 2 months.
Tea cultivation. There are big trees, my lord. I have annexed the photo.
Oh,
30,000.
photo we are not going. Trees, maybe trees. It is a part of tea garden.
Yes, my lord.
not part of tea
Tea
garden.
cultivation.
They have set up tea cultivation.
Maybe, but if it is a VCR, it's VCR, that's all.
VGA, and more so, my lord, that land has been allotted way back in the year 1994 to my lord Sports Authority for construction of that mini stadium. The total land quantum.
Where is this land?
My lord Tiok.
Yok, my
Yok,
lord,
mini stadium.
Abigaon. That is in 1970 onwards. This.
Mr. Borua, we cannot go to all this. Maybe in favor of eviction, maybe against eviction. But we will have to go through the what is material available. And already Salakuddin's judgment has been laid down. They will consider in terms of that judgment, that's all.
My apprehension is, my lord.
Notices have been served. Everything has been done.
No,
I have seen
this,
that.
Yes.
Section 18 notice have not served. It is
No,
a notice that
they-
we are delayed in filing application for settlement.
We do not think any
They
replies
have-
to be
they
filed.
have every
When,
notice
give a
of the
date, give a date. We are
After
wasting
vacation,
time.
your lordship. my
The
lord.
lordship may be pleased, my lord, immediately after the vacation, my lord,
Yes,
and
yes.
in the meantime, my lord, subject to outcome of what, my lord, decision is taken by the revenue department. Lordship will keep this pending, let the revenue department decision, my lord,
I
which
have
we
no
will get, my lord. I will place it on record.
We are not saying anything. We are just adjourning it on next date. We will decide it. An affidavit in opposition, reply affidavit has been filed by the revenue authorities.
Yes, ma'am.
Revenue authorities. Mr. Borua, learned counsel, submits that he may be granted some time to go through the same and argue the matter. Prayer is allowed. List this matter on
My lord, can it be, my lord, on 24th of October?
24th of October 2024. This matter should not be treated as part heard any further.
Earlier
And it
intended.
cannot go beyond 1 month.
Earlier intended.
Huh?
Earlier intended.
Interim order passed earlier shall continue till the next day.
Published.
I'm obliged.
This is item number, this was item number 5, 6 adjournments. 28.
This matter dispute related to allotment of a shop.
That's Hosai.
Hojai.
Code here and this settle the issue.
As because lordship, it is admitted.
Difficult. I have time and again I thought how to
No, your
No,
lordship, on
otherwise
last
also,
occasion I have submitted that ultimately it will have to be remanded to the
That- that
authority. It is
is-
factual
that
dispute, your lordship.
when.
And only thing your lordship will kindly note, your lordship, that your lordship, the petitioner must get in preferential treatment, your lordship, being the son of the earlier lessee, your lordship.
That
And
part
he is a-
lordship, that
that-
part they will decide. Otherwise, there is no
My lord-
procedure for legal.
And your lordship
lord,
will
I am
kindly
appearing
see, so
for
far
the
as the
stand of
other man is
indictment.
concerned.
My lord, the cause of action in the rate petition arises in 1994. They approached by filing this rate petition in the year 2019, my lord. From 1994 onwards, my lord, rate petitioner and the respondent number 5, my lord, occupying the shop and paying the rent regularly, my lord. Now in 2019, he came up before the court by filing this writ petition challenging that allegation, my lord. Secondly, my lord, in his writ petition, he has not, my lord, he has suppressed the fact that he is also an employee of the board, my lord.
It is
And-
there.
and-
No question. It is a fact, lordship. The respondent of
It's-
5 is a permanent employee, lordship. He is a tax collector, is a permanent employee, and he is a work
Now I am
class
retired,
laborer.
madam.
He
Now
is
I
a
am-
work class laborer. He is a daily wages, lordship. When
Now I am no more in
Not
service.
your-
when
And
work.
thirdly, my lord,
If you want to go,
Okay, daily
if
wage,
you want to go, we are ready
He is a
to
daily wages.
decide this matter.
Lordship may remand
So
this.
he's
That
arguing.
it is not for decide this matter here, lordship. It's a
And
remand back
my
the
lord,
matter.
1994, my delay and
You are
letter-
arguing. You have the answer right now.
Otherwise,
We'll
lordship,
see that how can you do this?
He-
Whole settlements will go set aside.
he is a
You could not have
I'm not-
acted upon such application. We'll set aside this.
whether
Okay,
he is
fine.
whether-
And we'll set aside the settlement and ask the authorities to act as per law to give the many people are in the street to come. We'll set aside everybody's.
And
Two brothers will set aside.
and in fact, you know, I have.
And
gone
we'll
to
set
that-
aside and thereafter remand the matter back
lordship.
to give allotment,
Lordship.
including the parties who are sick, who they may,
They
as
are
per
equal,
rule.
lordship,
As per rule, we do with competitive bidding and
lordship.
that's all. Hard.
That will lordship beneficial for.
That is what you wanted. Yes.
My lord, otherwise, my lord, let the board decide, my lord. That
Why should board decide now? Board will not decide, we will decide.
And it is admitted
That
fact that
options are given to you.
he is a employee lordship, whether he is retired or not, it is not a
I'm-
fact.
I'm-
But he was an employee or he is a employee lordship. It
Where is the
there.
impugn order?
imping order, my lord. That was pleading in the repetition.
No, Your
He
Honor,
wanted
there is
to
no
dispose of the
impugn order.
representation, my lord. And
We
once he
prayed
is a
for
part of the
inquiry.
proceeding, my lord, he has paid the, my lord,
That
tax.
is what we wanted to pass an order to dispose of his repetition. You are arguing, so we'll set aside both things. That's all. We cannot, since you are arguing, we'll have to answer this question. That's
My
all.
lord, I am just submitting, my lord, what
You are submitting what? You are submitting, he made a prayer. The authority says, okay, fine, we'll decide afresh. At that state, you are arguing this matter. So we are setting aside both of it because according to us, this is illegal. And many people are in the street to run a business in municipal market. They will also get more revenue. They will issue a tender.
By this time, my lord, it was the cause of action in 1994, my lord.
That's why we'll set it aside. Illegality is when it is by fraud or illegality, it is
There is no
start fraud.
fraud.
You want to answer, if you want an answer, we are here to answer. Which one you want? Set aside or remand it back?
Remand to back, my lord.
Then why unnecessary people argue?
My lord.
Yes,
Just my ideas may be recorded.
your hard. Mr. Bothakur, learned counsel for the petitioner. Mr. Gogoi for
Four lordship.
question number 1, 2, and 4.
And for 5.
5
My lord, for 3.
for 3. The grievance raised by the petitioner is to the effect that his predecessor in his or her is
Both the two, your brother and sister.
the two petitioners that their predecessor in interest was an allottee of a municipal shop under
Number
Lanka
17,
Municipal.
block 1B.
shop number 17, block 1,
Lanka Delhi Bazaar lordship.
1B in Lanka Daily Bazaar.
Lordship.
Full stop.
Under Lanka Town Committee. lordship.
Under Lanka Town Committee. It is alleged by the petitioners that behind their back a joint allotment, is that it?
Yes, sir.
Joint allotment was, the allotment was modified and the name of the respondent, number 5, was incorporated as allottee along with the petitioners.
Petition number
Okay,
1.
petition
Petition
number
number 1. Full stop. It is the case of the petitioner that the respondent number 5 is his cousin,
Lordship.
and taking advantage and claiming to be legal heirs of the deceased father of the petitioners. He got his name incorporated, being an employee being a permanent employee under the Lanka Town Committee. Full stop. On the other hand, it is the case of the respondent number 5 that the allotment, his name was incorporated as allottee in terms of a joint application made by the petitioner number 1 and the respondent number 5, and such material fact has been withdrawn. And therefore, there is no illegality in such allotment. Mr. Gogoi, in his usual fairness, submits that he has obtained instruction that the respondent number 5 was a
employee.
employee, tax collector under
Assistant tax daroga lordship.
assistant tax daroga,
Lordship.
and the petitioner number 1 was a
lordship daily wages.
daily wage earner under the Lanka Municipal
Lordship.
Lanka Town Committee. Full stop. Full stop. It is the prayer of the petitioner that he has already raised the issue before the Lanka Town Committee, raising his grievances, and therefore matter may be relegated to the authority to decide as regards the entitlement of the petitioner as well as of the respondent number 5 to being an allotee under allotee of the shop in view of the date of the original allotee. Full stop. Mr. Gogoi, learned counsel, has also submits that since some disputes are there between the contesting parties, the respondent number 3 shall be the best authority to decide the issue, and therefore matter may be relegated for the sake. The learned counsel for the respondent number 5 has also not objected to such prayer. Accordingly, the writ petition stands disposed of with a liberty.
My lord, my direct respondent number 3 as well as 4 also.
Respondent number 3 and 4.
3 and 4.
Representative is disposed of, permitting the petitioners to file a fresh representation before the respondent number 3 and 4. Respondent number 3 and 4 raising their claims, full stop, including their prayer for cancellation of name of respondent number 5 as allotee of the shop in question, full stop. On such application being filed, the respondent number 3 and 4 shall consider such representation and pass a speaking order as in terms of Municipal Act and rules, more particularly as regards the entitlement of allotment in terms of inheritance on the date of original allotee, full stop. While making such decision, a reasonable opportunity of hearing shall also be given to the respondent number 5 as he claims he has also asserted his rights, full stop. Accordingly, with the aforesaid observation, direction, the writ petition stands disposed of. The entire exercise be carried out within a period of 3 months, within a period of 3 months from date of receipt of a certified copy of this order. Full stop. To be furnished by, not full stop, to be furnished by the petitioner.
One line, your lordship, that your lordship, why that he has claimed that is on the basis of a application. That your lordship, I have your lordship disputed that by your lordship filing a ajahar before the.
That you see, therefore I was saying his right also be heard. We have said everything. Upper level, it is the allegation, last upper level, it is also the allegation of the petitioner that there was no joint application in as much as his signature was forged, and in this regard already an FIR has been filed.
My lord, my submission may be recorded, my lord, from 1994 till date, till 2019, he has not objected to
It
that.
is countering such argument, the learned, the counsel for the respondent number 5 submits that the such submission is not correct, in as much as the shop is being run in the joint name of both the petitioner and the respondent number 5 since 1994, and now he has become wise
Only in 2018. my lord.
wise in the year 2018.
Item 29, your lordship has directed us to file an additional affidavit. Initially, we have filed an affidavit wherein we had stated that by way of a notification, this area is taken under Kaziranga. What is the procedure, lordship? Lordship, I have already sent it for vetting. It's lacking on my part, lordship, because of my son's admission. I was out of state.
That is not his points. We have raised this. Yes. On the prayer of Mr. Sharma, matter stands adjourned to file the affidavit in terms of additional affidavit in terms of this court's earlier order dated 21/8/2024. List this matter.
Let it be after
After
vacation as
vacation.
because acquisition proceeding has not yet been initiated.
After vacation.
Matsudai.
Yes, PTC. Yes.
I have not received any written instruction, my lord. It's regarding supply of diesel and all this. No, I have checked up my lord, losses comes to page number 14. There is no work order, no date. In one day, it will be 1,65,000 and
No,
more.
that we do not know.
My lord, that's why, my lord, sometime we wanted to get the written instruction, my lord. Because,
That is what we have granted you on 9/9/2024.
my lord, this has not come, my lord. I have sent it, my lord.
So you verify and pay.
That can be done, my verify. The principal secretary will have to verify. Principal secretary have to verify.
Heard. Mr. S. Bora, learned standing no, sorry, Mr. M.S. Swencho, learned senior counsel, assisted by
Yes.
S. And Mr. Bora, learned standing counsel for PTC. The grievance raised in the petitioner is that it is 29/19/542. The amount is
29/95, yes.
29/19/542. Okay. See order dated 8/11/2021. Paragraph, second paragraph. Full stop. In support of such contention, the petitioner has also annexed a statement showing the details of bill maintained, the details of bill as annexed as annexer 1, prepared purportedly by the executive engineer within bracket PHC Gosaigaon division, Gosaigaon. Full stop. Mr. Bora submits that they will require to verify the details of such proposal sent by the executive engineer PHC and to find out the veracity. Full stop. And accordingly, he submits that after verification, if it is admitted amount shall be paid to the petitioner within a specific time period. Full stop. In view of the aforesaid consensus, the present writ petition is disposed of directing who will verify this?
Respond number 4.
It is directed that the respondent numbers 4 shall verify the claim of the petitioner as regards outstanding liabilities against fuel bills as well as the proposal submitted by the executive engineer within bracket PHC Gosaigaon division, Gosaigaon, by way of annexer 1 dated 2/8/2021. Full stop. And verify the same. Full stop. After such verification, if it the admitted amount by the principal secretary, Boroland Territorial Council, be paid to the petitioner within a period of 3 months from the date of verification. Full stop.
From today.
No, they will give them a verification period.
Verification have to be-
How much?
3 months within entire thing have to be verified and
Process will be done in 3
Okay.
months.
Such verification be completed within a period of
3 months.
1 month. Verification only.
And payment 3 months.
Then we give time for payment. Verification shall be completed within a period of 1 month from the date of receipt of a certified copy of this order to be furnished by the petitioner. Full stop. Thereafter, on the basis of the verification, the amounts admitted by the principal secretary, Boroland Territorial Council, be paid to the petitioner within a period of 1 month thereafter.
No, then
Okay,
total
okay, we do not want a contempt, 2 months thereafter.
Okay.
Accordingly, the writ petition stands disposed of.
Okay.
One second. Loilo, Kurilo. Silent.
31.
Made pleasure lordship.
We are going for final
Yes.
disposal. So can we take the others all 2-3 meters and finish it up?
And my friend will definitely take quite some time, Lord.
Ah.
So,
Can
Lord,
you
will
finish
kindly
up
give
today?
us,
Lord,
Will it be
I
possible?
will take half an hour,
Then
maximum.
in that case, Lordship will kindly give me time a day after tomorrow for my submission. I'll take about 3-4 hours.
Even we will not be able to start our part today. And probably they're not likely to conclude also. So therefore. our
see,
part-
I'm sure what
So let me start, my lord.
no, what I'm expressing is,
Yes.
we have time today, no problem on
Yes.
that. But if it is not completed again, it will go after vacation.
Because when the first round of hearing,
No.
in fact, it was heard for
What
4.
I'm saying, otherwise I don't have
Let
any
me
problem.
start, because
Lordship.
we are also in a hurry.
Okay,
Lordship.
Let me start.
Lordship, my submission is very clear.
It will be again, and 20
it will-
on reopening, I do not know.
No, but
See why I'm saying it.
Same position will happen when the matter is listed on another day also.
No.
So therefore.
No,
it
no,
has
but
to-
that I'm not saying. Problem is that had not the vacation not been there, and we do not know the roster immediately reopening.
No, what the lordships can do, my lord, I'll conclude
Ah.
maximum 1 hour, not more than
Okay,
maximum.
okay, fine.
So they can start thereafter.
My submission is when I have, in fact, this matter was heard for about 7-8 days. I took 3 days and I completed my argument before my Lord Justice SK Midhi.
Okay, that I have
No,
seen.
no.
Yes. So I can also argue, but I will take 2 days. It is not that because the facts are so lengthy.
I do not have any problem hearing this matter, but see again refreshing after vacation, that will be that may create a problem. To be frank, you know, I do not hesitate to
We'll
take,
give written argument. We'll supplement our effort by written argument.
but make it sure if it is a part hard matter, 20 after then when can you hear this matter for you?
If my learned
It completes today.
I can give my submission after tomorrow. It is not that I am shying away.
Okay.
I want this honorable court to hear the matter. But the only thing is that earlier round,
And Mr. Deka,
My lord, after Learned AG concludes, my lord, because.
I'll take 2 days, Lordship. I'm sure. It is a very lengthy matter from our perspective. My learned friend may complete it in 10 minutes, but from our side, we have to give the
1 hour time I'll take.
please advise what to proceed.
Let's start, my lord.
Okay,
Otherwise,
I have no problem
let's
on that.
start.
Then my submission, maybe if it is
Okay,
convenient, day
we'll
after
see on-
tomorrow,
Yes.
or maybe Friday, whatever is convenient to this.
Your lordship like to take up the other small matters or
We'll finish up the small
Yes.
matters.
So my colleague will be
See,
here.
well, what we'll do is let them be there. We'll finish the list and come back to you.
Yes. Or should I come at 2 o'clock, my lord?
How you can do that also
Yes.
at 2.
Better we come at 2 and I start.
Yes.
Yes. Oh, yeah.
I'm
deeply-
2 o'clock will be difficult for me because I have an NGT case in.
No, I'll argue. Somebody will take note.
Ask somebody to take a note. But even if he starts also, that may go to 2.
That'll go beyond.
No
Go beyond
difficulty.
We'll start at 2 o'clock. Deeply.
Where is the affidavit? State's affidavit.
Lordship.
What is their stand?
Stand is that lordship, there are 2 NOCs. Well, actually, lordship, in reply, I have stated that there are 2 separate areas of land.
No,
So
where is their affidavit? Let us see.
Affidavit, lordship, my lord, page 4, my lord, we have. Paragraph 4, my lord. Paragraph 4.
Where is the notice before cancellation?
This is not given.
Notice is not there.
Huh?
Their notice is not there.
Matter is there.
No procedure is followed.
Hard.
Here, my lord, lordship, Payus, my lord.
No, nothing is to be perused. I have seen the rule. There is no procedure of that. Where is the procedure of cancellation?
That 14/7, lordship, find at page 62.
Page 62.
I'm sorry, page 64, 14/7.
It simply says register is empowered to cancel the license of deed writer who is guilty of the disobedience of a lawful order.
Page 64.
64 or any other impropriety. But here it is a temporary establishment. He pay for because of writing deed, some fees is paid.
Heard Mr. Dekha, learned counsel for the petitioner, also Mr. The present application is filed.
Impugn order page 17 annex
The
3.
petitioner is a licensed deed writer. Isn't it?
Yes, yes.
Licensed deed writer.
Annex 1, annex 2.
The petitioner assailed the order dated 38/2023 issued by respondent number.
Respondent number. Sorry. By the deputy. Sorry.
By the district register.
Yes, district register. Respondent number
It is not this, number 9.
3.
Respondent number 3,
3. District register Dhubri.
comma, district register Dhubri. Just what was the dictation by the impugn? Issued by the Swencho, whereby the license of the petitioner has been cancelled. Full stop. It is argued by Mr. Dekha that the aforesaid license has been cancelled without giving the petitioner any opportunity of hearing. Thus, the order has been passed in violations of the principles of natural justice. Therefore, on this count alone, the impugn order is liable to be set aside and quashed. Yes.
Paragraph 6, my lord, please. We have informed him about the hearing, my lord.
Per contra, learned counsel for the respondent submits that learned counsel for the respondent, referring to the paragraph 4 of the affidavit, paragraph 6 of the affidavit in opposition filed, submits that the petitioners were informed to appear before the office chamber of Senior Sub Registrar Dhubri on 28/08/2023, and accordingly the petitioners appeared before the respondent number 3 on that date, but had misbehaved with the authority and also used unparliamentary language. And they have failed to defend the alleged forgery committed by them.
So it is not forgery. I have filed in my reply.
This is your argument.
Yes, yes, yes.
This is his argument.
Sorry.
Full stop. Heard the learned counsel for the parties, perused the pleadings, as well as also gone through the registration manual of Assam. Manual of Assam. Rule 14.7 of the manual empowers the register to cancel a license of any deed writer who is guilty of disobedience of a lawful order or any other impropriety. Full stop. In the case in hand, what is discernible from the affidavit in opposition filed is that the license has been cancelled. The license has been cancelled for the reason that the petitioners prepared forged sale deeds and appeared before the sub-register for execution of such forced sale deeds. And after scrutiny and verification of the relevant documents by the authorities, more particularly respondent number 3, found out that the NOC prepared by who is Suman Ahmed, petitioner number?
Suman Ahmed, petitioner number 2.
Petitioner, the NOC produced by the petitioner number 2 was a forged NOC. And what about the other?
Petitioner number one,
Hmm.
he said there is no such any allegation. He simply says that he is revoking the officers when at the time of hearing. He is the
So,
father of the petitioner number two.
So far relating to the.
Lordship,
petitioner
kindly for a
number-
moment, kindly have the reply. In reply, Lordship, what happened?
No, no,
Lordship,
we
they-
don't go to reply. The other contention, you just listen to my dictation.
Lordship.
The other, so far relating to the petitioner number one, the fundamental allegation is that during the hearing, he misbehaved with the officers. Full stop. The rule 14.7 of the manual empowers a register to cancel a license of a deed writer who is guilty of disobedience of a lawful order or any other impropriety. In the case in hand, though in the affidavit in opposition, impropriety as well as disobedience has been alleged. However, in the considered opinion of this court, such decision was an unilateral decision without giving any opportunity of hearing to the petitioner. Full stop. Principles of natural justice, give that paragraph is there already in that judgment. Principles of natural justice. In view of the aforesaid settled proposition of law, in the considered opinion of this court, the cancellation of license of the petitioner shall have a civil consequences inasmuch as it will involve the violations of the petitioner's right under Article 21 of the Constitution of India, more particularly for the reason that on the basis of such license issued in favor of the petitioner is carrying out their livelihood. Full stop. That being the position, it is correct to say that there is no procedure prescribed for issuance of any notice under the aforesaid Rule 14 within bracket 7 for issuance of any notice. However, it is by now equally well settled that until and unless the principles of natural justice is excluded by any statutory provision or by any executive instruction backed by law, the principles of natural justice is must be followed when the action takes away any right of any right of a person or right of the person aggrieved, or it results in a civil consequences. Therefore, even though there is no procedure prescribed for issuance of any notice, the action of the authorities in cancelling the license of the petitioner without giving them any opportunity of any reasonable opportunity of hearing shall entail the impugn order interference of this court. Accordingly, the impugn order dated so and so are set aside and quashed. However, the authorities, licensing authorities shall be at liberty to issue appropriate notice to the petitioners, giving them a reasonable opportunity of hearing and proceed thereafter, if so advises. With the aforesaid, the writ petition stands allowed.
But till then, their status may be restored.
That's all, set aside. What status?
They will allow.
Your order is gone, your
No,
license
because
is here.
this says they may be not allowed to enter the premises of the office.
Who
That may
said?
be indicated.
The interim order, if any, stands shall merge with the order passed today.
The register is also empowered somebody who is, let's say, someone doing any misconduct or illegal
That we
activity.
have already set aside.
Set aside.
Impugn order set aside.
Even though
Meaning there were what?
they may continue.
Nothing is there.
They may
They
continue.
That's all.
How
The
about
impugn order dated so and so stands.
30th August.
That's all.
Jeff Loveland. Let's say, may I take back the manual notes?
Give a copy to me.
Yes, Jeff Loveland. Then I will. It will remain. Obliged.
May I please? Lordship?
Yes.
Lordship, impugn order of the Assam Board of Revenue allowing the appeal that is case number 72 RA Dhubri oblique 2016 is under challenge in this writ petition. Case is that Lordship, one Helmeshu Roy was the original, is the riot under the original Pattadar. And he died in the year 2006. And prior to his death, his wife also died. They had no issue. In by an order dated 30/10/2014, passed by the Resident Settlement Officer, Bologons, name of the petitioner has been recorded as occupancy tenant.
Who is in possession as on date?
Lordship,
Who is in possession?
petitioner is in possession.
According to you are in possession.
Original tenant, my lord.
Uh-huh.
We are the legal heirs of original tenant.
Who is in possession?
My contention is that I am in possession.
And his contention,
He is-
you are
he is
in possession.
No, did not prove Lordship. They are the legal heir. The,
So, whosoever is possession, who is aggrieved, go to the civil court.
yes, Lordship, that is the question.
That's all. Nothing more, nothing less. We cannot decide all these things.
Because Assam Board of Revenue has decided the title in respect of the land. Lordship.
It
That
has
is-
not,
that is the
Not decided.
not decided.
Not
by-
decided.
And any question regarding legal heir is to be proved in the civil court.
Not really. Yeah. They can very well see. See, what is the order, earlier order passed in your favor? Let us see.
At page Lordship, 15 Lordship.
It's 15.
Yes.
Yes, what it says.
Both the parties have given their respective haziras. Notice has been issued. Latpandal Kanangu has given the field verification report. The opposite parties have also given haziras, have not given any objection. The matter has been put up today for final disposal. It is seen from the report of Mandal Kanangu and from the relevant record that rioti record.
Now, Basiruddin Sarkar, from whom you have become under whom you were riot? Huh?
Under the original Pattara Lordship, Bhuvan Chandra Burman, Boykunthan Chandra Burman, and Pranhari Burman. They are the
Where is your righty Khatiyan?
Lordship.
Where is the discussion that this is the righty Khatiyan?
They are the original Pattadars Lordship.
Who is the original Pattadar? These
The
Bormons.
Burman Lordship.
Bormons are original Pattadar. You claim that I am a riot under them.
Claiming that I have been possessing the land
Ah.
since last 20 years
Ah.
and also paying revenue, some taxes to them. And as per the field verification report,
So you say correction of rioti record on the basis of possession. Is it permissible?
it is not permissible. Lordship.
If it is not permissible, Deputy Commissioner's order is wrong.
But the question, because any entry in the revenue Lordship is to be made on the basis of actual possession.
No, in case of riot, it is not. In case of riot, it is something different because there is a landlord, there is a tenant. He is a riot and it is inheritable. Priority right is inheritable. Even he is entitled for title if he files an application and fulfills the condition under some temporarily settled areas tenancy act.
It is inheritable Lordship.
Isn't it?
But
So even they are entitled for how you become a tenant under whom? Huh?
He is claiming possessory right.
That is what, but it's a correction of
And,
righty record on the
same
basis
cannot
of
be-
possession.
Same
That
cannot be
itself,
decided in the under some temporary.
that
area.
itself is not permissible.
Not permissible.
and their claim is also not.
Then forget about them. You are the person who initiated correction of righty records. That has been allowed. How can that be allowed? Without you being satisfied to be a riot, forget about legal as who is legal as who is not.
My only submission in Lordship, any disputes for the title.
No, there is
the
no
parties may
title. You
approach
are
the
admittedly your possession. There is no question of title. Now come to the order of the Deputy Commissioner. Page
At page 23 Lordship.
Page 20. As some temporary settled areas tenancy act, give us. Hard. Yes, tell us anything to be added? Nothing in your case. You have
Only
enjoyed.
submission in respect of any right, both the parties should approach the civil court.
No, right should be approached to the civil court only when there is you are a legal heir or you are some claiming that I am a tenant.
Yes.
You are a tenant. You are not claiming as a tenant.
Tenant. He is
That's
not
all.
claiming as a tenant.
Tenant.
He is claiming simply as a
Possession.
possessor. Right.
Lordship, may kindly peruse page 14, Lordship.
You
The-
may file a suit, it's up to
Yes,
you,
sir. Yes.
up to him.
But Assam Board of Revenue held their Lordship, they are the tenant. And
Because,
to
because
restore
they
their-
are the tenant, because their names were recorded earlier. Your name is incorporated later.
They are not recorded. They did not apply for mutation, Lordship. In respect of
Understand,
the
but
land.
they are
Mutation is not the question.
not the question. Question is who is liar?
Raya.
As far as their
Do you understand? Forget about them. It is you who have initiated the project, saying that please give me possession, give me mutation on the basis of possession
Yes.
against the Rayati Khatian. Is it not permissible?
and that is not permissible.
If not permissible method and ends there. If you say that I am possessing, I want a declaratory right on the basis of adverse possession, file a suit.
The Assam Board of Revenue, Lordship, in the impugn order, directed to record their name as tenant because they have never applied. That is the wrong.
They have never applied. That may be wrong. Their father's name is there.
No, not father's name, Lordship. Because they are the legal.
Forget about
son
them.
of their brother.
What is your right? Tell us to incorporate in that mutation. Tell us you
I
what
have
is
only
it?
position, Lordship.
Huh?
I have
So
only
you have possession. You be there in the possession. File a suit for suit against them for on adverse possession.
Maybe observed, Lordship.
That will observe. That we will just observe that he will be at liberty if he claims any right over the land through a civil suit. That's all.
I title in.
Any right. He can possessory right may be declared. His right may be ascertained in a suit. It's up to him. Heard, learned counsel for the petitioner. The present writ petition judgment form. Present writ petition is filed. Is directed against a judgment and order dated 23/9/2019 passed by the Assam Board of Revenue in case number 72 within bracket RA within not within bracket 72 RA within bracket DBR/2016, whereby the challenge made to an order dated 24/8/2015 passed by the settlement officer Dhubri in miss case number 1 of 2015, dismissing the appeal of the respondent number 3 and 4, upholding an order dated 30/10/2014 of the settlement officer Golagganj Revenue Circle passed in mutation case number 122/2014.
Miscellaneous case. Miscellaneous.
Passed in miscellaneous case. Miscellaneous case number 122 of 2014. The brief fact of the case is that the petitioner hearing applied for correction of a royalty record registered in the name of royalty record, full stop. In the said royalty record, one Hel Mechu Roy was registered as riot under landlord, namely Boikuntha Chandra Bormon, son of Vishnu Bormon, Bhuvan Chandra Bormon, to Boikuntha Chandra Bormon,
Page 15.
both son of Vishnu Bormon and Pranhari Bormon, son of Pushpa Bormon, in respect of a plot of land measuring 15 lesas in Dag number 319/170 of KP Patta number 71/177 of village Kedar Part 3 and in respect of a plot of land measuring 3 kathas 10 lesas bearing dag number 321 slash 271 of KP Patta number 71 slash 117 of village Kedar part 3. The petitioner sought for correction of such royalty record in his favor on the basis of his long possession.
On the basis of.
On the basis of possession, comma, Sukani Patta, and on the basis of paying land revenue to the Jotdars from last 20 to 25 years. The learned, said petition, said application was registered as miscase number 122/2014. Who passed this order?
Assistant settlement officer.
The assistant settlement officer, Golagganj revenue, assistant settlement officer, Golagganj circle, by order dated 30/10/2014, allowed such application. However, the order reflects no reason and consideration on the basis of which such order was passed. Even there is no discussion as regards the LS Sukani Patta and payment of land revenue.
No notice was also issued.
Full stop. But both parties have given, then we are not going to that. Full stop. Accordingly, by the order dated 3/10/2014, the settlement officer directed to correct the record and
My lord, may I point out? Notice was issued to the Pattada, not to the Riot.
no, that is not reflectable. Why should we go to that?
No, there is
Where is that? Notice issued to whom?
only Pattada.
We do not know.
No, it is in the name of Vishnu Chandra Burman. Case number can.
Okay.
Case 15.
Okay. We'll come to that. Accordingly, record were directed to be corrected. As riot under the original Pattadar on the basis of actual possession. Sukani Patta and revenue paying records to the Jotedars.
Not Patta, Potro.
Potro, not Patra. Potro. That. The order also reflects that the original landowners are made second parties in the proceeding, and no notice were issued to the riots. Full stop. No issue to the riots. Though admittedly, the order dated 30/10/2014 itself reflects that name of the riot is registered. Therefore, full stop. Being aggrieved by the aforesaid order, the respondent numbers
3 and 4.
3 and 4 claiming to be the legal heirs of original riots, legal heirs of the original riot, preferred an appeal before the deputy commissioner. Is that it?
Settlement officer.
Settlement.
Before the settlement officer, and the learned settlement officer also decided the matter on the ground that the ASO has on the ground that the ASO had concluded that the applicant in miscase number so 120 so has been possessing the land since 20/25 years, and that the respondent possesses the required record for recording his name as tenant as per provision of some temporary settled areas tenancy act 1971. However, what are those materials to come into a conclusion is neither dealt with nor any discussion has been or reason has been made. And thus dismiss the appeal preferred by the respondents, preferred by the respondent number 3. Being agreed, the respondent approach the Assam Board of Revenue, who in turn interfered with the decision of both the revenue authorities, that is assistant settlement officer and settlement officer, settlement on the basis of the record. The Board of Revenue came to a conclusion that the present appellant was not a present appellant or his predecessor were not tenant of the land in question prior to granting the prior to passing of the impugned order, and one Helmesus Roy, the predecessor in interest of the appellant, was the recorded tenant of the land in question, and after his death, your names are recorded, not recorded. Was the tenant? Was the tenant? It was also concluded that the order has been passed without giving any opportunity of hearing to the present appellant for furnishing authentic documents to prove that they are the legal heirs of the deceased riot, the deceased recorded riot. And accordingly, the orders were set aside. In the aforesaid background, the learned counsel for the petitioner submits that the Board of Revenue could not have passed such an order holding the appellants to be the legal heir of the original riot, legal heirs of the original riot, recorded riot, inasmuch as such determination can only be made by a competent civil court. Therefore, the respondents ought to have been relegated to a civil court for ascertaining their right, title, and interest. This is your argument?
Yes, sir.
It is his further contention that this court has perused the material available on record. Admittedly, the order dated 30/10/2014 passed by the settlement officer, by which the assistant settlement officer, by which the petitioner has acquired a riot status of a riot,
Occupancy tenant.
status of an occupancy tenant, discloses that one Helmesu Roy is already recorded as riot over the said land. Therefore, in the considered opinion of this court, firstly, a notice ought to have been issued to the said riot or his legal heirs, as the case may be. Full stop. It is an admitted position that prior to passing of order dated 30/10/2014, neither the name of the petitioner or his predecessor in interest were recorded as occupancy tenant in respect of the land in question. It is also an admitted position that the petitioner claimed for mutation of his name as Rayat on the basis of his position. Full stop. Though the settlement officer has passed such an order, however, nothing is discernible. The reason on the basis of which, reason/consideration on the basis of which it came to an conclusion that the petitioner is an occupancy tenant. That being the position, this court that being the position, the determination made by the Board of Revenue cannot be held to be a perverse decision or a decision without jurisdiction. And therefore, this court, in exercise of its certiorari jurisdiction under Article 226 of the Constitution of India, is not inclined to interfere with the decision of Assam Board of Revenue. Full stop. Assam Board of Revenue. Full stop. Accordingly, the present petition stands dismissed. While parting with this record, it is made clear that if the petitioner is having any claim over the disputed land, he may file he may approach appropriate civil court for seeking such relief, and in the event such relief is sought, the same may be decided as per the material and evidence that may be produced by the petitioner
As per law, man.
as per law.
As per law.
As per law.
Because
As per law.
one submission, my submission may be recorded, my lord.
Yes.
He is claiming occupancy tenant.
Mm.
In this case, question of occupancy tenants do not come under, because this land is not fall under urban areas.
Mm.
It is land under the Assam
So,
temporary.
temporarily. So,
Temporary.
yes,
So
that was
question of occupancy tenants does not come.
that he will establish as per law. Deka. Decolita. No, sorry, sir. Item?
I appear for the private respondent number 4 in this matter. This matter
None
become infructuous.
appears for the petitioner on call. Full stop. The matters pertain to a challenge to an action of the respondent in holding the respondent number 4 to be technically eligible in terms of note NIT dated 28/1/2023 for carriage of free textbooks for class Sreni, with it in inverted comma, to class 12 for the academic session 2023. Full stop. In the meantime, initially there was an interim order. However, this court had vacated such interim order on 16/3/2023, and it is submitted by the Learned Council for the respondent number 4 that the work has already been executed by the respondent number 4. Full stop. That may be the reason why the petitioner, the Learned Council for the petitioner, is not present before this court when the matter was called. In view of the aforesaid, the writ petition stands dismissed for non-prosecution. How many matters?
Met results, yes. Well, what had happened in this case? The petitioner, Meghamalar Estates, is on to a real estate business, my lord. Now, on its own, Meghamalar Estates and Services wanted to develop this particular project. Sometimes in the effort was started sometimes in 2009, sorry, 2015 and all. Eventually, a permission was given on 2010. I'm just briefly indicating, I'll come to the facts. Now, there were a lot of litigations going on because an organization by name Turun Nagar Unnayan Committee filed a petition before this honorable court saying, how come because of the narrowness of the road and all, how come such a big project can come here? So a lot of litigation ensued. Eventually, this honorable court ruled in the favor of the petitioner, saying that they may go ahead with the project. Now, the second permission was issued sometimes in 2017 and 18. Now, at that point of time, the floors permitted were 7 to 9.
In the year 2017.
17 to 18. Now, my lord, again some problem developed, again some litigation. So everything was in standstill. Then there was a time came where the petitioner was compelled to construct a bridge connecting Torunnagar bylane number 2 with the particular site. By investing about 60 odd lakhs of rupees, bridge was also constructed. After permissions and all were regularized, and because of economic reasons, he could not pursue it. Meanwhile, he took loan from the petitioner took loan from NETFI. So the account was about to be declared as an NPA. In such a situation, the petitioner entered into an agreement with respondent number 5, that is Protect Housing. Now, the understanding was that 35% of the built-up area would be given to the petitioner number 1, and the rest would be of the petitioner respondent number 5. And all the liabilities and all would be looked after by respondent number 5. Now, precisely, if your lordship would kindly come to page number 52, a particular clause in that agreement, which was the bone of contention.
52.
Page 52 of the writ petition, my lord.
Yes.
Para 15 on top. That the first party.
Just a minute, just.
First party in that agreement. Your lordship got it. Para 15. That the first party, that is the petitioner, permits the second party to take possession and start the work from there signing this memorandum of understanding. And second party will take care about NOC, permission, renewal, etc. Further, the first party has no objection if second party uses or at its own cost apply for and obtain fresh permission and or renew by modifying the existing NOC as per the bylaw. Now, this is very important. And in such an event, the benefit therefrom will be available only to the second party. Both the parties agrees that the above 35% of the total saleable area is as per FAR allowed in the above referred present NOC received from the competent authority shall only be given to the first party by the second party. No further area share will be given by the second party to the first party if the second party gets additional affair under provisions of law. Now, what this particular clause permitted was, my lord, that the second party, whatever is in accordance with the bylaws, they may apply for fresh permission and all. And if it is given, then he will have the enhanced thing will be enjoyed by the second party. First party will have not anything. But in this regard, we have invoked an arbitration that is going on. We say our share cannot be confined to 35. That is going on. That's a separate cause of action. But I'm not troubling on lordships. Now the question is, here, my lord, two things arises. Here, this is where the public law element comes in. Now it says, by modifying the existing NOC as per bylaw. So if you want to take any now, end of the day, what is happening, my lord? In this project, I am still 35% owner. They are 65% owner. My logo is being used
So
for
you
marketing.
want your property to as per your bylaw.
That's my case. That is where I would like to invoke the public law doctrine. For a moment, I am not troubling.
Just a minute. Just vibrating the table. Why this? First time. Yes.
Yes. So, my lord, this is actually the turning point in this case. Now, let me place the facts. Please come to me, lord. Page number.
What is your prayer in this petition?
My prayer is, my lord. Kindly see, my lord. I am praying for quashing my lord, permit given by GMDA and GMC, because this is in accordance.
According to you, it is in
I'll
violation.
just, when I unfold my case, lordship will find startling facts. So basically, that is my case. Yes. Now, my lord will kindly come to page number 116. Initially, an NOC was given sometimes in 2010. I am not troubling your lordships with that. Please come to 116. Now, this is the office of the Guwahati Metropolitan Development Authority. Now, this is what they call it, development, my lord, permit. There are two, lordship knows. One permission is given by the GMD, other is by the building permission is by GMC, and planning permission is by GMD.
This is by GMD.
GMD. Can you see, my lord, with reference to your application for permission to erect a building at village Japurigov, Moja, so and so, on, can you see, 4.9 meter and 8 meter wide road for residential complex purpose in accordance with the plan submitted with it, which area of each floor and setbacks as shown below. So now lordships will find basically these are
4.9 meter and 8 point wide. Wide can be one only.
no, my lord, there are two roads. One is 4.9 meter and other is 8 meter.
Okay.
Yes.
It is.
I'll give the map. Yes. Now, therefore, my lord, this was the permission given. Now, if your lordship will kindly see, it was the second, then maximum was 9th floor.
Just a minute. Highlighter and wrong bench.
Floor bila kote?
Yes. Yes. What you want to say?
So, my lord, kindly see. Now, different blocks are there. In some block, it was 7th floor. In some block, it was 9th floor. So, this is how the planning permit was given in 2017. Then my lord will kindly come to GMC এখন কি?
Next page.
এইটো কি হইলে?
It was in 18 of permission.
কি হয় এইটো?
Next 17 hour for renew.
Then my lord will kindly come to page 2117. This was on 3rd November 2018. With reference to your application for permission to erect a building at village Japurigo of Beltola Moza under so and so on 4.9 meter and 8 meter road wide for residential complex purpose in accordance with the plan submitted with the area each floor and setback as shown below. So my lord, these are the different permission, the bill, units which permission was given. Now, my lord will kindly take note of the road width, my lord. It was 4.9 and 8.
Same.
Same. Now, my lord will kindly come to page number 88. Now, after that MOU.
Page 88.
8. Now, after my lord, it was taken over by respondent number 5. This is the planning permit which was issued by GMD.
R5. Respondent 5.
Yes. No, not R5, my lord, by GMDA.
No.
In favor of respondent number 5. Yes. My lord will kindly see planning permit. Kindly mark the date, my lord.
I am marking the date.
10th of September 2020. Now, if your lordship would kindly come to the reference. Application dated 1/9/2020 submitted by Messrs. Protect Housing, represented by Manoj Kumar Jhala. So within a span of 8 days, 20-story permission is given, my lord. I wish, my lord, every person gets permissions like this.
Let us not go to
No,
this.
I'm just saying.
Let us go to
Yes,
the
yes, yes. Then, my lord, will kindly come to page number 93.
Just a minute.
Yes. Oh, yes, sorry. The road width is important, my lord, at page 88.
Just a minute. 19.
My lord will kindly note the name of the road and road width
Where is that?
on right-hand side, last column on middle, my lord. Immediately below number 2,
Remarks.
Japurigo,
Remarks.
on page 88, my lord.
Page 88.
On the right-hand side,
Particulars.
particulars.
Dag number Moja, Patta number
Now
Moja.
see, to number 2, Japurigo, 8.35 meter average. Earlier it was
Number 2.
4.9 and 8. Now it has become 8.3 meter average. Because, my lord, the moment it is 8 plus, then the FIR is 275. Earlier FIR given to the petitioner was 175.
And what is that 4.65?
4.65 meter. Now
No,
the
one is 8.35 meter average.
8.35 is the average, my lord. They say one road is of 4.67 meter, other is 5 meter wide. Existing road. Yes.
Average of the road. Height of the
My
building.
lord will kindly come to the next page. Please come to the next page, my lord. Page 89.
Yes.
Serial number 4. This planning permit is issued on the basis of recommendation of 3-member committee constituted by GMDA so-and-so dated 3/9/2020. On 1st, my lord, the application was filed. The departmental minister constitutes a 3-member committee. And on 10/9, my lord, the permission is given. And in between, there were 4 holidays. I'll come to that, that we have stated. Lordship, may kindly here take note of this few things, my lord. 1/9 is the revised application.
I will tell you, 1/9 is the revised application, 3/9 is the committee,
Yes.
10/9 is the permission.
My lord, in between, there are two dates, my lord will kindly take note. 5/9 committee inspects the site.
Where do you get that?
I'll show my lord.
Okay.
I'll show, my lord. I'll show that. 6/9 is a Sunday. 7/9 Madhav Dev Tithi. 9/9 Janmastami. And 10 permission given. My lord, in this regard, at page 582 in our affidavit in reply, we have made the relevant amendment. Page 582 in our affidavit in reply. I can place that, my lord.
We'll go later on.
Yes.
I've just noted the.
Yes, yes, my lord. Now, the TMC issues the Millard NOC for construction at page 93.
Just it. Dated
19/9/2020.
page 93.
Yes, Millard. Now, on the right-hand side, if your lordship kindly comes, block A, lower ground floor, lower ground plus 11, block B, lower ground plus 10, block C, lower ground plus 21, block D, lower ground plus 21, and block E, lower ground plus 13. Earlier, I have already shown, my lord, it was 7 and mostly 9. Now, my lord, let us come to this controversy regarding how this road has all of a sudden become so wide. Earlier, my lord, by virtue of average width being 7.5, my lord, the affair that was permissible was 1.75. In fact,
earlier road was 4.9.
4.9 and 8. Average, it was taken as 7.5.
7.5.
Right. In fact, what had happened, my lord, when the earlier litigations were going on, TMDA was asked to clarify the position when the Torunagar Union Committee filed that case. That report is there at page number, my lord, 124. That will clarify everything. Kindly see, my lord, page 124 is my application, our application, then 126 is there. Page 124.
Just a minute.
No, again, 124 new application.
Page 120.
124 million, 19/11/22. When I got to know about the new permission, then I started taking up the matter. Because tomorrow, my lord, if a criminal case is filed, I will be a co-conspirator. Because government of Assam nowadays, drop of the hat, they file criminal cases, my lord. What had happened to the gentleman called Dipankar Bura, we all know. He has a lordship's got it.
Yes.
Page 120. The authority will recall that Meghamala's flagship project under the name and style of City Center Residency at Torun Nagar was stalled for years because of public opposition raised under the banner of Torun Nagar Unnayan Samiti. Meghamala had all the necessary permission from all the authorities to proceed with the project, but could not proceed because of public opposition to the project. A protracted legal battle had ensued, and during the proceedings, Guwahati Metropolitan Development Authority had to submit relevant documents to the High Court, justifying why the project got legitimate approval for construction of the project. In this connection, I would like to inform you that GMDA had submitted to the High Court a brief report on the points raised during hearing held on 23/12/13 in connection with WBC number so-and-so of Meghamala Estates so-and-so. A copy of the report is enclosed and marked as Annexure 1. The said report certifies Torun Nagar bylaw number 2 to have the average width of a 7.5 meter. Subsequently, the High Court ruled in favor of the Meghamala and the project was restarted with renewed permission from all the concerned authorities. Unfortunately, Meghamala could not continue with the project and project was taken over by Protect Housing. Protect Housing redesigned the project and secured fresh permission from all the authorities to relaunch the project under its banner as Protect Torun Nagar. However, when Meghamala reviewed the permission received by Protect Housing, it has revealed some gross irregularities. The primary irregularities relate to GMDA declaring road width of Torun Nagar byland to be 8.35 meter. This declaration has entailed Protect to become eligible to claim FIR of 2.75. It is very surprising that the authority is contradicting its own report submitted to the High Court as detailed above. Now, my lord will kindly come to the report as page 126. Brief report on the points raised during hearing held on 23/12/13 in connection with WPC number so-and-so. Now, please come to me, Lord, the 2A. These are all provisions are quoted. 2A. Existing road width as on 24/12/13 along Torun Nagar byland number 2 from the Torun Nagar main road to the proposed site of Meghamala Estate Services is found to be as follows. Kindly see me, Lord. From chain edge 0 to 30, it is 7.40. Kindly similar. Similar, it is chronologically given.
Highest is 8.50.
My lord.
Highest is
Okay,
8.50.
at one particular.
One point at
one point.
Yeah, 1
Yes.
point.
See, therefore,
So therefore,
average road width is
7.5.
7.5. Now, my lord, most interestingly, please kindly allow me to read complete this, my lord. There is another road. My lord, when we cross the Rajgor bridge, we can take an immediate right turn. Then we can go towards Rajgor. Then, my lord, one road goes straight.
In front
Just
of
by the parallel by the Bhorolu.
Hmm.
That is only not even 5 meters. This is the road. The existing width as on 24/12/13, this is Anil Nagar Road. Along the road linking the site and Rajgor main road is found to be as follows. Kindly see me, Lord. The average is 4.68 meters.
that is 4.68.
Yes. Now, kindly come to the last sub-para. However, as per the file record, the average road width of Torun Nagar byland number 2 was taken as 8 meter average during the year 2008. And based on this average, the average road width of 8 meter, the proposal was approved, considering the fact that there are 2 other connecting roads to the site. Actually, my lord, there is one Hendurial is there. Now, in the new permission, that is also not there. Now, please come to the next page. The FIR allowed then was 175 against permissible 200 due to variation of road along with the Torun Nagar byland number 2 in the CTC meeting held on 23/12/08 and 3109, which recommended the proposal for approval with condition stormwater drainage will be allowed and developed through the plot of land surrounding the area of Anil Nagar and Nobin Nagar to minimize the waterlogging problem. The existing road width now available along Torun Nagar bylane number 2 is less than that was existing in the year 2008. When the plots abutting the road were developed and boundary walls were not erected, and there is apprehension of encroachment of the road since the year 2008 by way of development of the abutting plots. That means, my lord, this measurement are of 2008. When this report was given, it was felt that because the boundary walls and wall were not given, now there could be some more encroachment, therefore the road width might decrease. As regards the mentioning of the proposed road width of 8.5 meter, as mentioned in the NOC, it is stated that FAR is allowed based on existing road width and proposed road is considered for determining front setback so that provision in road widening in future may be facilitated. That means, my lord, whenever it mentions the, as my lord, 8.5, it was only for the purpose of, my lord, setback.
Setback, because if you come front, if road is expanded, then you will come nearer. So
Yes.
it is always in a higher side.
Absolutely. Now the question is, now because this road has become all of a sudden widened, now they have got, my lord, more than 150 lakh square feet, my lord. Now I'll show, my lord, what has happened.
Yes.
My lord will. 140 government. Now kindly see, my lord. We have made some homework, my lord. Project site is the middle one. Anil Nagar bylane is that green. Torun Nagar bylane number 2 is that blue. And Henduri Ali is that orange. Now, when we took the permission, my lord, this road was also insisted on because Henduri Ali, eventually it will connect with Juru. Now it is not there. Now kindly see. For clarity, the approach roads to the project site are highlighted as under. Anil Nagar bylane number 1 is green, Torun Nagar bylane number is blue, Henduri Ali is orange. Project site is located in Anil Nagar and Navin Nagar area and were earlier approachable only through Anil Nagar bylane number 1 and Henduri Ali. Anil Nagar bylane number 1 and Henduri Ali were narrow roads and not suitable as approach road for proposed project. Torun Nagar bylane number 2 being wider was more suitable as approach road. Accordingly, a bridge was proposed connecting the project site with the Torun Nagar bylane number 2. My lord will kindly come to the next page. A bridge over Bhorolu was constructed as per the approval and order number of DMDA. Anil Nagar bylane number 1 was extended up to the bridge head by surrendering land from the project site as no road existed for providing required connectivity between Anil Nagar bylane number 1 and Torun Nagar bylane number 2 as per the order above. Then please come to the third drawing, my lord. Project approval received and Anil Nagar bylane number 1 was extended to a point beyond the project site. Anil Nagar bylane number 1 remain as dead-end road beyond the project site. Then fourth, when Protect Housing took over the project, they shifted the boundary wall in front of the plot and made Anil Nagar bylane number 1 into a wide road measuring more than 12 meters in front of the plot. Well, this is the game, my lord. Supposing, my lord, the Rupnagar road runs from, my lord, my house, right hand point, up to Birubari Tini Ali, my lord. Now that road is, say, my lord, the 7 meter wide. Now what I do, I bring my boundary wall towards my own place. Say I keep 10 feet. Would the road become wide? It is possible, my lord. When big people are involved, this is how things are done. Now this green portion, my lord, after that turning, this is what has been done. Taking advantage of this, my lord, a 4.5 meter road has been shown as, my lord, 8.5 meter. 12.5. Then my lord will kindly come to the drawing number 5. Protect housing got a new NOC with an enhanced FAR of 2.75 by submitting falsely that the widened portion of Odil Nagar bylaw number 1 is a part of the Torun Nagar bylaw number 2. So my lord, this is the game. Now, Lordship is exercising power under Article 226. A blatant illegality has come to your Lordship's notice. Therefore, we are before your Lordships. Now, my Lord will kindly come to how they have evaluated this situation. Please come to page number 188.
Yes. This is the meeting.
Yes.
The three member.
Yes. My lord, I'll make my submission. There was already a order of this honorable court under the scheme of the GMDA Act and GMCA. This committee, they have no locus standi. They can't do. This was constituted by the minister himself because his both sons are involved. No, that's a pleading, my lord. I'm not making that allegation.
Okay.
We have made them parties.
Okay.
It's no allegation.
He was the chairman.
He was the chairman.
See, I want to go through the pleaded case.
Yes.
Not,
Oh, no, my lord,
them.
I'll not utter a single word which is not supported by pleading. In fact, my lord, they were subsequently made parties. Minister is respondent number 6. And 2 sons of the minister are the director of the Protect, respondent number 5 company.
Okay.
A proposal of group housing residential apartment building comprising 5 blocks submitted by Messrs. Protect Housing was received online. However, due to large size of the proposal could not be processed online as, as auto DCR software failed to run the program and halted time and again after certain limit of progress. This has been duly examined and certified by C. So-and-so. Thereafter, applicant submitted hard copies of the proposal for further scrutiny and proposal of the planning permit proposed, which is considered.
Even voluminous, so hard copy.
In the meantime, Chairman GMDA, that is the minister, having order dated 3/9/20 constituted a 3-member committee with the following members for scrutiny and recommendation of planning proposal over 10 bighas of plot area. Ananta Kumar Gogoi, Deepak Besborua, Deborah Kolita. The committee examined the aforesaid proposal and visited the site on 5/9/2020 to study the ground situation. The measurement of the road was taken by Subhas Mondal and Torun Das of GMDA at various sections of the road. Width of the road, Torun Nagar, at the last junction point leading to the plot in front of the plot and at the point where the road width is minimum are as follows. Entry point near Namghar 8.05, in front of the plot 12.5, minimum width breeze 4.50. Okay. As per Guwahati Building Construction Regulation bylaw so-and-so, the average road width is defined as follows. Now, my lord, the matter is very simple, my lord. What they say, now because, my lord, that the frontage of the plot is only 70 feet. Nah? Huh? Excellent. 1 second, my lord. Front is excellent. No. No. Front is two. Plot to front is two. I'm just giving it, my lord. Now, after quoting that provision of the bylaw, my lord, what they say, on the basis of the above provision, as the road width is not regular, and average width of the Torun Nagar bylaw number 2 is found as follows. 8.05 plus 12.5 plus 4.5 is equal to 8.35. How is it possible, my lord? My lord, let a fresh inquiry be committed, my lord. Thereafter, lordship will impose as 1 crore cost. We'll bear it if it turns out to be correct. My lord, is it possible 70 feet or 70 meter, my lord, the frontage? At the asked to verify. Because the boundary wall is taken back to road which is become board. What about the frontage? What about the Henduri alley? Bylaw number, as per bylaw number so and so, the wider road is to be considered for determining building height and other regulation, which is as follows. Yes, if the road was really, my lord, actually when we enter from Rajgor, the frontage will be maximum 4.5. Now that road has been constructed to be 12.5 meter. Highly similar. The map which you have given, that is the actual position. Just they have taken back the boundary wall. If that entails higher, then my lord, I stand to correct myself. If that is the position. Huh? No, mati to frontage to. Itu frontage to kimar. এখানে কথা রাস্তার কথা বলছে এই হাইকোর্টের মাটিখিনি ফ্রন্টেজ টু বহা কেন 5.5 মিটার দেখো দিয়া provided that the authority shall prescribe different front or rear open space, front or rear setback, considering space required for widening of road, minimum space required. In case of building abutting two or more street, the wider street shall be considered for the. Well, yes, if there are 2 or more roads, the wider street will be considered. I am not on that. Question is, how can Anil Nagar road be considered as 12.5 meter road? When the frontage is 4.5, when dead end, that is your project side. I think the frontage is 70 feet. Just 70 feet of land. That
you
is
want to say that 70 feet, even if you increase to 12.5.
no, not a 15 feet. Let us consider 15. So see, the road width cannot become more, my lord. Is it not a travesty of justice, my lord? As there are 2 roads, one rear side north road so and so, which is 5 meter wide, and average road width of Bhorolu River side linking Rajgor main road, and the proposed side is found to be only 4.67 meter. The wider road of Torun Nagar is considered for the proposal. My lord, Torun Nagar is 7.5. That report is already before this honorable court. Where from this 12.5 has come, which has a, my lord, the extent of my lord, arbitrariness which has crept in the decision-making process. My lord, there is nothing in this report. The report only says, there refers to 2 provisions, saying that in case there are 2 or 3 roads, the road whichever is wide, that will be taken for the purpose of determining the admissibility of affair. That we are not disputing. Question is, how can you construe either Torun Nagar bylaw number 2 or Anil Nagar road to be millard of 12.5 meter? When a report was submitted by the same authority before this honorable court, where it was said that it is only 7.5. Now, therefore, my lord, this is a case where the minister has, number one, he should not have been involved in the decision-making process because his 2 sons are involved. Respondent number 6 is the minister. His 2 sons are involved, therefore he should not have been involved. Now, my lord will kindly come to I'll just refer to 2-3 pleadings in my writ petition, my lord. Please come to para 22. My lord, my basic
Which paragraphs? Which paragraph will read?
para 22, my lord,
Huh?
para 22 and para 24.
Page.
Page 20. Para 22. That the petitioner respectfully begs to state that as per the legal wrong which has been caused to the petitioner for entering into MOU dated 9/11/19 and deed of agreement dated 6/6/20, the petitioner will pursue its legal remedy in appropriate forum. That is, I am saying regarding the arbitration. However, the
That
present petition,
respondent company is a limited company or partnership firm?
it's a limited company.
Limited.
Udai. Huh? No, director also. I think they would be in a
Partnership.
partnership. Partnership company can it's a partnership.
Partnership.
Sorry, firm. However, the present petition has been instituted to redress the grievances arising out of the planning permit and NOC issued by GMD and GMC respectively. What is evident from the facts narrated in the preceding paragraph is that respondent number 5, in collusion with GMD authorities, managed to get FIR of 2.75, when in law, the entitlement is only 1.75 or at best 2. This has become possible because Vivek Anand Singhal and Lokesh Anand Singhal, who are partners of respondent number 5 partnership firm, are sons of Ashok Singhal, who is the Minister of the Housing Affairs and Irrigation and Administrative Ministry of both GMD and GMC. It is the specific contention of the petitioner that it is a unique case where minister has blatantly misused his position to do undue favor to respondent number 5 for wrongful gain, where both his sons have decisive stakes along with their partner Manoj Kumar Jalan. It is worth mentioning that because of the enhanced FIR, the respondent number 5 stands to gain approximately 2.5 lakh square feet of saleable area. When this enhanced FIR of 0.75 is computed in terms of money, it comes to approximately 150 crores. Therefore, what is evident is that in order to make the windfall profit of 150 crores, where everyone gets a piece of pie, the above illegality has been committed by respondent authorities. Nothing more is required to show the abuse of the power by executive at the behest of a minister. Though Ashok Singhal has not been arrayed as a party respondent, petitioner craves leave to array him as a contesting respondent if the situation so demands. So subsequently, my lord, this honorable.
What is the number of your respondent?
6. 6. Now, my lord, let me paraphrase my arguments. When Meghalaya independently applied for permission, my lord, the road width was taken as 7.5 meter, and which is rightly so. And because that was done pursuant to an order of this honorable court, in the form of a report which finds place at page 126, that was submitted. It was clearly said there are 2 roads through which this plot can be accessed. One is, initially there were only 2 roads, Henduri Alley, that is blocked, and this 4.5 meter Anil Nagar road. And Torunnagar bylane could not be connected because in the absence of the bridge. Subsequently, bridge was constructed. Therefore,
4.5 meter.
4.5 meter bridge. And therefore, the average was 7.5. Therefore, if the road width is 7.5 or even 8 also, then the permissible FIR is 1.75. But if it is 8 and above, then the permissible FIR is 2.75, which has now been given. How it has been given? First, the minister respondent, now let us not use the word minister. The respondent number 6, my lord, he constitutes a committee. The committee is constituted on 3rd. 5, 6, 7, 9 holiday, 10 permission is given. And my lord, let us think, my lord, things have improved, people have become efficient, therefore work culture has increased, therefore it is given. Now issue is how have you given it? While giving, you have construed the road, which was earlier 7.5, to be now maximum with having 12.5 meter wide. Because, my lord, it cannot be construed as Torun Nagar byland because Torun Nagar byland ends at the bridge. Thereafter the project, in between only Nagar, thereafter the project. So how Torun Nagar, that even if it is construed to be 12.5, it cannot be a part of the Torun Nagar, it will be a part of Anil Nagar road. So from whatever angle we see, my lord, it's a case where they could not have. Now, my lord, what does the law says? First, my lord, if your lordships, I'll just place that order. His judgment to court. If your lordships would kindly take the affidavit in reply filed by us.
Page.
It starts at page 575.
Starts at page
575. my lord.
575. Yes.
Please come to page 585. Assuming without admitting that three-member committee is valid, page 585 on top.
585. 8. Yes.
Assuming without admitting that the three-member committee is validly constituted, perusal of the minutes dated 5/9/20 clearly reveal the erroneous computation of average road width for the purpose of determining permissible affair of the said committee. Three-member committee took recourse to para 26(3)(4) note to calculate the average road width. Three-member committee had come to a finding that plot in question has tri-connectivity and same is not denied by the petitioner company. And average road width of Khenduri Ali and Anil Nagar was shown as 5 and 4 points respectively. However, three-member committee is silent about methodology as to how the committee undertook measuring the aforesaid two roads. With regard to Torun Nagar bylaw number 2, committee came to the following finding. As per the report dated 28/12/13, page 32, the average road width of Anil Nagar, Torun Nagar bylaw number 2 was 7.5, and report indicates the methodology as to how average road width was arrived at. At the relevant point of time, building bylaw 2006 was prevalent, and section 22, the so-and-so, which is perimetria to 26(3)(4) NB of 2014 regulation, which dealt with calculation of average road width for the purpose of calculating FR. Further, as per aforementioned report dated 28/12/13, average road width of Anil Nagar bylaw number 1 as 4.68. Now, three-member committee, while calculating the average road width, have calculated the following: entry point 8.5. My lord, just it is not possible, my lord. In front the plot 7.5. In the report dated, the widest point was portion was 5.10. As well as the wall of the plot has been moved back, the widest portion comes to 12.5, and as such the calculation becomes so and so. Minimum road width of the bridge is 4.5. As such, the average road width of Torun Nagar bylaw number 2 comes to 6.57. However, the three-member committee, instead of considering the actual road width in front of the plot, considered 12.5 meters as because respondent number 5 moved the boundary wall backwards. This action of respondent number 5, as well as action of the respondent authorities, is wholly illegal and against the spirit and mandate of the bylaw. So this is our case, my lord. Now, my lord, regarding this committee, this three-member committee, the efficacy or legitimacy of this committee, please come to 591. There is an order of this honorable court, my lord, which is still holding the field. What had happened? This writ petition was instituted by Assam Real Estate and Real Infrastructure Developers Association, ARIDA. if your lordships will kindly come to page 592, first subpara, aggrieved by notification dated 19/10/20, issued by under Secretary Government of Assam Guwahati Development Department, constituting a single window clearance committee with departmental minister as its chairman, the writ petitioner, which is an association of real estate developer, has approached this court by filing the present writ petition, inter alia contending that impugned notification is not only arbitrary and illegal, but same is also in conflict with the provisions of the statute. Now, my lord, may kindly skip that. Please come to page 596. Last para. Having regard to the fact and circumstances of the case in its entirety, it is hereby provided that until further orders, single window clearance committee constituted by impugned notification shall not in any manner interfere with the functioning of the GMD and GMC authorities in discharge of their statutory function as per the provisions of the Act and bylaws so and so with regard to sanction of planning permit and building permit. So, my lord, other than the authority, any other authority cannot deal with this. Here
What about the finality of distribution?
No, this is pending. That stay order is still holding the fee. No, what is fully, I think, my lord, this order has been made absolute. And that information I'll have. WPC 5320/20. WPC 5320 of 2020. Absolute close করে
Okay.
Yes. Now, my lord will kindly come to page 602 of this affidavit. Any longer, no?
Last order.
No, my lord. Finally disposed of, it says single window cannot. The last order is consequently it is observed that single window clearance committee so constituted by the impugned notification cannot consider any building proposal. The meaning thereby, my lord, GMD and GMC, nobody else. So this 3-member committee has no legs to stand. Just to facilitate your son's thing, you cannot appoint committee. Yes. My lord will kindly come to page 602.
Yes.
When, my lord, those earlier round of litigations were going on, then CEO of GMDA wrote to the Deputy Commissioner Kamrup. This is on 9/1/2015. NOC for construction of bridge was issued by GMDA white dated 22/10/09 on the basis of NOC issued by Water Resources Department dated so and so. Subsequently, on the basis of the bridge and Torunnagar bylaw number 2 as the main access road to the project site, NOCs issued in favor of Meghamallar were issued in favor of so and so. However, the NOC could not be renewed or extended as the bridge could not be constructed by the party concerned and stop construction notice had to be issued. Then para 4. The construction of the bridge across Borolu at chain is 7.25 meter linking Torunnagar bylaw number 2 and Anilnagar bylaw number 1 will certainly enhance the connectivity between the two sites, and in a disaster-like situation, disaster management team may operate through the road bridge linking to serve in the inside localities of Novin Nagar, Anilnagar directly through project site as proposed by the petitioner. The developer Meghamallar is to abide by all terms and conditions put in the NOC of the Water Resources Department and GMDA for construction of the bridge. The bridge should be treated as a public bridge once completed and accessible to general public for all occasions. Now, this is important. The developer Meghamallar Estate and Service Limited shall have to agree to spare a private thoroughfare of 20 feet wide across the project site from south to north directly linking Torunnagar bylaw number 2 in a disaster situation for use by general public and disaster management team. When the FIR was 1.75, these were the conditions, my lord. Now these all have evaporated. So to deal in a disaster situation, 25-foot wide thoroughfare was ordered to be kept. Now these are not there. Then please come to the next page, my lord. These are all missing in the new thing. This is on 20/2/2015. This is a communication by commissioner to the GMC to the commissioner. As there is a proposal to extend the proposed area up to Henduri Ali of Nobin Nagar, the road running through the complex connecting Henduri Ali and bylaw number 2 of Torunnagar should be completed and maintained in a good condition and left open to public for use. Kindly see, my lord. Anil Nagar, though it is a narrow lane, that would be there. Now Torunnagar bylaw number 2 will connect the project site. Within the project site, there will be a 24-feet wide road which will connect Henduri Ali to Juro. Now these are not there.
So meaning there are almost two plots. The plot is divided into two plots by 20.
Earlier, yes, earlier. Now, my lord, the floors have become 21. Now these conditions are not there. So squeeze as much as possible. Then my lord will kindly come to page number 623. Eventually, my lord, this is the order by which permission for bridge was given. Now, at page 623, whereas a petition, public petition was submitted by Meghamolar Estate and Services Private Limited regarding construction of a bridge over river so-and-so, which stopped by number dated so-and-so due to public petition received from Torunnagar Unnayan Committee. I'll not trouble your lordships with all the facts. Please come to page 624, last para. In view of above, I, Sri M. Angamathu, Deputy Commissioner and Chairman, District Disaster Management Authority, Kamrup, have no objection if permission is given by GMD or GMC or any other authorized authority for construction of bridge over Borlu River at chainage number 725 under the strict supervision of Water Resource Development along with gradient. Regarding construction of bridge, GMD may review earlier NOC issued. The entire work is to be completed within 15th of March 2016. So this is how, my lord, the bridge was constructed. Then accessibility of Torunnagar bylane to the site became possible. And when petitioner was given the permission, there were 3 roads. Anil Nagar, Henduri Ali, one via the project and other one connecting so-and-so. Now, my lord, we all have seen Anil Nagar and Henduri Ali are less than 5 and Torunnagar bylane was 7.5. Now, my lord, how this is possible? Well, at the end of the day, these are all public authorities, my lord. They hold in trust, the public trust. This is not how, my lord, you should exercise power. You are a repository of public trust. Merely because minister is giving dictation, this 3-member committee should not have abdicated their conscience. This is very unfortunate. Now, my lord, I'll pay facts. As far as facts is concerned, these are the facts. Now, let me place 2-3 case laws on the point. First, my lord, I've brought all the copies, my lord. I'll hand over all. Rajnarayan. I brought all the copies, sir. Okay. I'm always. First, my lord, will kindly have this Dwarkanath, that is AIR 1965.
Subbarao.
Yes, my lord. Please come to para 4. Now, my lord, lordship is exercising power under Article 226. In my humble submission, my lord, this is the basic structure of the Constitution.
No
Any
doubt.
illegality coming to your lordship's notice in a public law remedy, my lord, lordships will take note of it. We shall take the preliminary objection, para 4, my lord. We shall take the preliminary objection, for if we maintain it, no other question will arise for consideration. Article 226 Constitution reads as follows. Now, I'm skipping that quotation, my lord. The article is couched in a comprehensive phraseology, and it expressly confers a wide power on the High Court to reach injustice wherever it is found. The Constitution designedly used a wide language in describing the nature of the power, purpose for which and the person or authority against whom it can be exercised. It can issue writs in the nature of prerogative writs as understood in England. With those in England, but only draws an analogy therefrom. So, my lord, the ratio decidendi of this judgment, in my humble understanding, is in a public law remedy, which is supposed to be the basic structure of the Constitution. If any illegality comes to the notice of the court, this honorable court can always take notice of it and remedy the situation. Here is a case, my lord, a minister who has misused his position to favor his two sons. What he has done, my lord, he has given an extra affair. Now, kindly see, my lord, how this man will enrich. In terms of money, it comes to 150 crores, we have already said. So, my lord, why? We are governed by rule of law. There is a set of rules and regulations. How can you overcome this? So, therefore, my lord, this honorable court has the necessary power to take note of such illegalities. Next, my lord will have Assessor Nath. My lord, 59 Supply 1 SAR 59 Supreme Court 149.
No, it is not here.
No, I'm sorry. My lord, this is actually SCR, what is available in SCC online. I'll rely on para 15 and 36. But it will air, my lord, it is 32 and 53.
I'm having the SCR.
Yes. So 15 and 36.
15.
Yes. My lord, I am placing the judgment for the proposition that there is no question of waiver of fundamental right. If fundamental right is there, I cannot waive it. It is such a sacred right. The Supreme Court felt that we must give an interpretation that even if a citizen gives up, the court will not take note of that. This, in my opinion, para 15 is the true position. It cannot therefore be urged that it is open to a citizen to waive his fundamental right conferred by Part 3 of the Constitution. The Supreme Court is the bulwark of the fundamental rights which have been for the first time enacted in the Constitution, and it would be a sacrilege to whittle down those rights in the manner attempted to be done. So, my lord, this is the, then please come to para 36. Is the finding. I would hold, therefore, that decision of this court relied on by the learned Attorney General do not help him in establishing waiver. Let me now examine the circumstances on which the learned Attorney General found this plea of waiver. Indeed, it is true that the SSC submitted to the discriminatory procedure applied to him by the Commission. He also asked for a settlement under which he agreed to pay 75% of his alleged tax liability and a small amount of penalty. He made some payment in installment even after Muthia's decision in December 1955. Do this circumstance amount to waiver? It is to be remembered that in 53 and 54, when discriminatory procedure of act was applied to him, the report against him was made by commission on which settlement is based. The SSC did not know, nor had it been declared by a court of competent jurisdiction, that section 5(1) of the act was ultra vires. In his application for state settlement, he said clearly in para 3 that commission announced it as its view that the income, profit and gains that had escaped assessment in the hands of SSC was so and so. The SSC also knew that under the act, this finding was final and binding on him. If in these circumstances, the SSC made an application for settlement, can it be said that this is a voluntary or intentional relinquishment of a known right? I venture to think not. It has been said that waiver is a troublesome term in law. The generally accepted connotation is that to constitute waiver, there must be an intentional relinquishment of a known right or voluntary relinquishment or abandonment of a known existing legal right or conduct such as warrants an interference of relinquishment of a known right or privilege. Waiver differs from estoppel in the sense that it is contractual and is an agreement to release and not to assert a right. Estoppel is a rule of evidence. What is known legal right which the SSC intentionally relinquished or agreed to release in 1953-4? He did not know when that any part of the act was invalid, and I doubt if in the circumstances of this case, a plea of waiver can be founded on the maxim of ignorance of law is no excuse. I do not think that the maxim ignorance of law is no excuse can be carried to the extent of saying every person must be presumed to know the piece of legislation enacted by the legislature of competent jurisdiction must be held to be invalid in case it prescribes a differential treatment, and he must therefore refuse to submit it or incur the peril of the bar of the waiver being raised against him. I do not think that such prescience is a necessary corollary of the maxim. On the contrary, the presumption, if any, which operated at the relevant time was the presumption that a law passed by the competent legislature is valid unless declared unconstitutional by a court of law. My lord, the purpose why I have relied upon the judgment is, my lord, a citizen sometimes, my lord, having regard to different circumstances, may hesitate, may not hesitate. But when these facts come to the notice of the court, and especially when the court is exercising function in the public law realm, court must take note of this. The idea is, my lord, I have a right of equal treatment. If I have been denied equal treatment by the authority in the form of any protection, any privilege, any liability, then court must come to the rescue, my lord. Because even if I want, I cannot, waive my right. So this is what the value of constitutional right is. Then, my lord, I will rely upon one judgment. This is Dhampur Sugar. For, my lord, how public authorities are supposed to exercise their function, my lord. This is 2007, 8 SCC 418, para 81 and 82. Now it is at page 447. Now it is well settled and needs no authority for holding that every power must be exercised bona fide and in good faith. Before more than 100 years, Lord Lindley said in General Assembly of Free Church of Scotland, I take it to be true that there is a condition implied in this as well as in other instruments which create power, namely that power shall be used bona fide for the purpose for which they are conferred. In other words, every action of public authority must be based on utmost good faith, genuine satisfaction, ought to be supported by reason and rationale. It is therefore not only the power, but the duty of the court to ensure that all authorities exercise their power properly, lawfully, and in good faith. If powers are exercised with oblique motive, bad faith, for extraneous or irrelevant consideration, there is no exercise of power known to law, and action cannot be termed as action in accordance with law. My lord, I'll repeat the last sentence, my lord. It is therefore not only the power but duty of the court to ensure that all authorities exercise their power properly, lawfully, and in good faith. If powers are exercised with oblique motive, bad faith, and for extraneous or irrelevant consideration, there is no exercise of power known to law, and action cannot be termed as action in accordance with law. But as all, anyway, this is the proposition which I wanted to place. So if court finds that a power has been exercised for oblique purpose, for reasons which is not bona fide, then court must come to the rescue of the citizens. My lord, one passage from Rajnarayan judgment. Please come to para 74, my lord. Rajnarayan is 1975 4 SCC 428. My lord, it was more in the context of seeking some privilege, my lord, but nevertheless, I think it is fundamental into our case. That's why I thought I'll just bring it to your lordship's kind attention. In a government of responsibility like ours, where all the agents of the public must be responsible for their conduct, there can be but few secrets. People of this country have a right to know every public act, everything that is done in a public way by their public functionaries. They are entitled to know the particulars of every public transaction in all its bearing. The right to know, which is derived from the concept of freedom of speech, though not absolute, is a factor which should make one wary when secrecy is claimed for transaction which can at any rate have no repercussion on public security. To cover with veil of secrecy the common routine business is not in the interest of public. Such secrecy can seldom be legitimately desired. It is generally desired for the purpose of parties and politics or personal self-interest or bureaucratic routine. The responsibility of officials to explain and to justify their act is the chief safeguard against the oppression and corruption. Well, though the observation was in the context of some privilege was being sought regarding disclosing some information, nevertheless, these are all fundamental. End of the day, you are a public functionary. You do not have anything else. There are some statute, some guidelines which define your contours of work. You have to do within that. When it comes to giving a fare, you will go by the width of the road. The width of the road, you have already said it is 7.5. Now, how come it has become 12.5? Only because the minister's son is involved. You can't do that. Then Milord will kindly take this, this Ashok Kumar Yadav's case, my lord. This is on the propriety of the minister. He should not have been party to this transaction, my lord. He should have stayed away because his son is involved. Please come to para 18. Lordship, note this Ashok Kumar Yadav is a case of, but nevertheless, my lord, same principles apply. Para 18.
Just a minute.
We must straight away point out that AK Tripark case is a landmark in the development of administrative law, and it has contributed in a large measure to streamlining the rule of law in this country. We would not like to whittle down in the slightest measure the vital principle laid down in this decision, which has nourished the roots of rule of law and injected justice and fair play into legality. And you see the language, There can be no doubt that if a selection committee is constituted for the purpose of selecting candidate on merit, and one of the members of the selection committee is closely related to a candidate appearing for the selection, It would not be enough for such member merely to withdraw from participation in the interview of the candidate related to him, but he must withdraw altogether from the entire selection, and ask authorities to nominate another person in his place on the selection committee, because otherwise all the selections made would vitiate on account of reasonable likelihood of bias affecting the process of selection. So, my lord, this is a development of law in administrative law, not only my lord, in matters of interview and some, everywhere. Now, can we, my lord, visualize a situation? All right, there is no law. Propriety demands. And kindly see the end of the day, lordship will kindly see the consequence of the minister's interference in this case. Can we see, my lord, such a big project? I don't think there is any 21-story building in Guwahati. I think this would be the first. I think it has already been constructed. Now, my lord, the minister is giving permission. He should have said, since my son is involved, I'm staying away. And on this ground alone, this entire thing should go back.
Yes.
Therefore, my lord, so, my lord, for the present, I think, my lord, this is my submission.
What about the state of Punjab? Davinder Singh.
No, my lord, that I will not place. There is on waiver.
Okay.
Not necessary. That is on waiver. So, therefore, my lord, to sum up my argument, my case is very simple, my lord. It's a pure and simple case where the minister intervened to favor a farm in which his two sons are partners. And the illegality stretches so long, my lord, that a 21-story permission has been given, that too by construing a 7.5 feet road as a 12.5 meter road. It defies all logic, everything, my lord. These are all greed for money, nothing else, my lord. Therefore, lordships will interfere with this permission and set aside everything, my lord. And I reserve my right of, basically, I did not take your lordship's time more than this. If they come up with anything else, I'll reply.
Yes, when?
19th, my lord.
Huh?
19th.
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 Keep some clips. Call someone. This page will product in this page. This says me. Yeah, it should be, huh? Just wait for a minute. Yes, what about the unlisted?
I'm deeply obliged.
What is your instruction?
The only thing is that today is the last date, Lordship. Other participant will come again and say like this, we have not submitted this, given us.
Till 6, Lordship. Lordship,
Today is
I just want
till
to show you,
6 p.m.
Lordship. This bid value is of
P.N. Chaudhary, learned senior counsel, has concluded his senior counsel, assisted by Mr. Nalse Das, has concluded his argument. First of Mr. Bora, S. Bora, learned counsel, assisting the Advocate General. Advocate General appearing for GMD, appearing for the respondent, GMD and GMC. GDD. Press for an adjournment and for adjournment, prayer is allowed. List this matter on 19 for argument, reply argument of the Advocate General. First of all, I didn't part for it. 19th. That's all. And then when will you? Advocate General will take 3 days.
So perhaps,
We are also, because earlier occasion, we took 3 days.
earlier our turn did not come in late.
Okay.
That is the only problem we will having.
Lordship,
Other will come and say. we
let
will
them not open.
Short date may be fixed, Lordship, let them not open, Lordship.
What is the construction of?
No.
It's a supply of toys, learning and playing kit.
Now, nowadays problem is, what will be the meaning of that not to open if you are not allowed to participate? Can you submit, you cannot
Lordship,
submit?
I
to
just
the-
want to show you two pages, Lordship.
No,
page-
that we understand, see.
Now, in earlier occasion, they extended thrice, Lordship, and that value was 30 crore. This time it is 70 crore, Lordship. Lordship, may kindly see the earlier tender at page 39. Page 39, Lordship. Bid was dated
When
14/8.
can you submit your bid?
1 week time, Lordship. 5 days, Lordship.
No.
Till Friday.
If you say we can give us a day's time, we'll submit tomorrow, that is a different.
Lordship, by Friday, Lordship.
Difficult, see, when the tender was issued?
On 7th, Lordship.
7th of?
7th, 9.
9.
This
So-
month.
7/9.
Today is 17,
You
10
ought to have
days.
come immediately saying that the only 10 days time is granted. You have come today.
Lordship, they came on Friday. Saturday, Sunday was holiday, Lordship.
They came on, so what was the 7th is, what is the 7th is Monday?
7th was Saturday, Lordship.
7th
7th was Saturday, Lordship.
No, let us see, huh?
7th was Saturday,
7th was Saturday, Lordship.
7th of September.
September.
Yes, Lordship.
Okay, 7th was Saturday.
Then thereafter Sunday, Lordship.
So today is,
17.
you had the whole week from 9 to 13.
2 days was Lordship, second Saturday and
You ought
Sunday
to
again.
have come here challenging this petition, challenging that it is less time.
Lordship.
Today it is not possible at the end time.
Lordship, can we see that they have earlier extended
Maybe,
thrice,
maybe,
Lordship.
see, you know the writ court's jurisdiction.
Page
Can we say that, no, you extend it?
Page
Difficult,
50 for a while.
difficult.
Page 50 for a while, Lordship.
Until and unpaid?
Page 50. They have extended that 24/8 thrice, Lordship. Page 50. Not once, Lordship. 3 occasions, Lordship. Last
This
date,
same tender.
no, the 24/8 tender, which I have shown you, Lordship.
This relates to what?
The 24/8 page at page, this
50.
tender, Lordship.
Page 50.
Yes, page 50 is the extension given. Page 39 is
No,
the
what
that
was the
tender.
tender here?
Page 39. A2PSL supply.
Smartphones. This is for the smartphones.
Same department, Lordship.
No, what was the project here? Supply of what? Smartphones.
Smartphone.
And here this time,
Learning and
kits,
playing
Lordship.
kits.
Playing kits.
These are ICDS projects.
This value was 30 crore and
no, that is not the issue. Issue is they have given 10 days time,
Lordship.
rightly, wrongly. Okay? You are aggrieved.
Uploaded on Saturday.
You are aggrieved on Saturday, Sunday, you are aggrieved on Monday, you are aggrieved on Tuesday, you are aggrieved on Wednesday, you are aggrieved on Thursday, you are aggrieved on Friday. Saturday, Sunday, forget. Now you are here on Tuesday.
Today is
We
the last.
filed it yesterday. We filed the petition, Lordship. Lordship, let them not open, Lordship. Let me take instruction, Lordship.
What instruction will they take?
Whether it can be extended or not.
Today is the last date, Lordship. After 6 PM is there.
Hard.
Others are also there, Lordship.
We understand, hard. Mr. Chakravarti, learned counsel for the petitioner. The present application is filed. Challenging impugned tender notice dated 7/9/2024. Well, you have challenged, what is qualification criteria?
Lordship, those, Lordship, those are, I'm not skipping for the time being, Lordship.
So challenging certain conditions, certain qualifying criteria prescribed under tender notice dated 7/9/2024. The further prayer is to extend the time of submission of bid documents at least for 15 days to enable the petitioner to submit their bid. And in the interim, it is prayed that the respondents shall not be allowed to continue with the tender process.
Open the bid.
Huh?
Today is the opening date.
Not to open the bid, which is fixed today at 6:30 p.m. Where is that? Page 39.
No, Lordship.
Where is your tender notice? Page? Huh?
Page 18.
Page 18, Lordship.
E-procurement.
Yes. Sir.
What is the Act says time period? E-procurement rules.
Okay.
You show us some right. There is an e-procurement
Lordship,
rule,
this-
statutory rules. What is the time
This is the rule,
prescribed?
but the relevant page is not here, Lordship.
What is the prescription?
That I could, it is
That could
170.
have been a case that this rule prescribes this, they are only this.
It is 170.
Oh, we cannot do on mercy.
That's true, Lordship.
You'll have to show us a right that this is the minimum period. Because nobody except you have come here. The tender. Where is that tender? Tender?
Page
18.
Page 18, Lordship.
You want it. That procurement rules is here. E-procurement rules.
Ministry of Finance, Department of Expenditure.
No, this is by the state. There is state.
Oh, this is
State
central.
rules.
This is central, Lordship.
Specific state rules for e-procurement. Specific rule how to give, what should be consideration for what should be minimum time as per the rules. Then you can have a case that this is the prescription under the rule, tender is in violation. Then we can of course say that not to proceed. But you must give us some handle. We are not on mercy. Give the tab. Because I still remember the rule says it must be wide publication. This and this, there may be some day period. We cannot give that in case of mobile they have given. Mobile is a different thing. That cannot be right. We want at least you to be better prepared.
Lordship, and by proxy, Mr. Sarania was supposed to be, he has to leave for some adjournments.
Sarania is always half-hearted. Sorry to say that. What about the Act, 2017 Act?
In seeing that act also, there is there's
Anything?
not reflected here, Lordship, anything. In 2017,
In the rules, it is said that if they should declare the period, stages.
The time frame for submission of bids and minimum modes of for publication.
What is that, rule or section? Rule or act?
Six.
Six?
Six, Lordship, I'm saying Lordship.
Section 6 or rule 6?
Lordship, it's section 6.
Participation of bidders. Now, rule 9 says time frame for processing, section 9. And it says there should be prescription in rule. What is that rule? Until and unless you can say, cannot show us, how can you pass an order?
That aspect is perhaps not here. Only the time processing was there, is there, Lordship.
No,
But how much time should be given for to the bidder? That
no
aspect
time
is
frame for processing.
processing. Processing
subject-
will start after the submission, Lordship.
No, kindly read. Subject to the rules as may be made by the state government in this behalf, every procurating agency predetermine a reasonable time frame for
For completion
completion of
various-
stages of process of procurement. So stages of procurement includes a tender and indicate the same in pre-collection documents, bidder registration documents, or bidding documents as the case may be. There shall endeavor to adhere to the
Lordship, that-
time frame indicated. Okay.
Lordship, that reasonable time is there. The way the 10 days is reasonable or not, that aspect is also.
But you
We
have
look
become
into-
wise. Show us the rule, the corresponding rule to this rule. Rule 9.
Rule 2 আছে নাকি? Rule 2 আছে?
Yes, you see, matters to be included in procurement plan. Rule 4, sub-rule I. Time frame for the bid process. Hard. Mr. Sagot, Kalani Kufolo, challenge is venture. Legally, player venture. The subject bid reflects that the bid was issued in GEM government e-marketplace on uploaded on 7/9/2024 and the bid and the bid and date and time was 17/9/2024 at 18 hours. And bid opening date was fixed on 17/9/2024 at 18:30 hours. Full stop. Full stop. Therefore, 10 days time was granted for submission of bid. The petitioner has approached this court today, that is on 17/9/2024, alleging that the time granted for submission of bid is not a reasonable time. Full stop. And therefore, submits that the matter should be examined and the process of bid should be stalled. Full stop.
Lordship, Rule 5 says something about the time time deadline of the submission of bids.
What it says?
It says as if there is no sufficient participation, it can be extended.
No, yes. Only the full stop. So therefore, they have earlier, they will say that we have extended. That is what I'm saying. I got somewhere 10 days. Approach this court today only. Therefore, this court is not inclined to pass any interim order stalling the bidding process. Full stop. Mr. S.S. Roy, Learned Counsel, Standing Counsel?
No,
State Counsel submits that he may be allowed to obtain instruction in this regard, in as much as number of participants in the bid process, for the reason that Mr. Chakraborty, Learned Counsel, submits that the the limited date period granted for submission of bids will invite less participants. Full stop. Accordingly, let this matter be listed on
Day after tomorrow.
day after tomorrow.
Till then, Lordship, let them,
We'll see, we'll consider the interim
till
plan
then, no,
on the next date.
then, Lordship.
They will not.
Day after tomorrow, nothing will happen, Lordship.
Nothing will otherwise happen. They will submit today. What are the other dates?
Only opening. dates there.
What are the other dates? Space?
Lordship.
In 18. Another date to be on.
This is two bed. Huh?
Two bit.
Then they will push price bid. Technical clarification, they can give 2 dates. Nothing will happen. Today is the last date. They will open. Then for 2 days, they will seek clarification. Then price bid.
Lordship, for 2 days, let them not take.
They cannot take because they are timely. Yes.